Peace to the gods, peace to the gods. Yusef here again. Welcome everyone to High Frequency Radio. Tonight we have another video review tonight. I should start calling these video tutorials. I think I came across this video and I thought that it would make a good teaching tool because it's something that you see that happens quite often in court when individuals go in and they try to say that you don't have jurisdiction over me, that I'm not a 14th Amendment citizen and things of that nature. And I thought it would be pretty interesting to look at some of the things that the judge is doing or the administrator is doing in these particular proceedings, and and trying to speak on that a little bit. I got a couple of others too that we're going to look at. We're going to look at about 3 different videos tonight, not just one. All right? Because these videos are short, but I think they're going to be good. Peace to the gods out there. Let's get the likes up. As you come in, hit the like button. That is for the analytics for the channel. I appreciate when you like and comment and subscribe. I appreciate all of that. Make sure that you hit the like button. Make sure that you comment. Make sure that you subscribe and hit all. That's going to ensure also that it helps the analytics and ensures that you are, you receive a suggestion from YouTube for videos like this. All right, and as you come in, as I said once again, so let's get right to it. I'm not going to hold y'all up. Let's get to it. Let's check this out real quick and see what we got. Another sovereign in court. And the judge is trying to run over his rights. So let's take a look at this and let's see what's going on here. Hold on just a second. Let me... All right, let's check this out. Let's see what we got.
All right, next cases the court's going to call will be State of North Dakota versus Michael Scott Jacobson, file 26, 2023, CR 36, 26, 2023, CR 16, and 26, 2023, CR 50. Present in court, Attorney Mary Depute for the state.
I'm here by special appearance as the executor.
Please have a seat. Please have a seat.
Okay, now the laughing that you hear is somebody who edited that in. The anti-sovereigns, they try to make people look foolish. They want, people who don't know anything about this, when they come across these videos, to think it's some sort of comedy show, and it's not. The interesting thing here that I want you to pay attention to is the subtle tactics that are utilized by the judge. He's telling him to sit down. That right there is obtaining jurisdiction by you following the orders of the judge. Dorothy, there's some videos put out by a gentleman, Dorothy Gale. I'll see if I can download some of these while y'all are watching that, where she actually, whoever made those videos, they're cartoons, but they're very, very good videos. They show you a lot. They used to show you how to handle 1099 OID threats from the IRS, and they took them off YouTube. They took all, they never came back on YouTube, and I haven't been able to find it anywhere. However, what's really interesting is these are some things that a lot of today the people have gotten away from, following orders of the judge, where you're claiming that he doesn't have jurisdiction over you and he tells you to sit down and you sit down. And Dorothy Gale, how she handled it is, I will sit, is it all right, if it pleases the court, I will take a seat right here at this table. He said, when he said, sit down, sir, he said, if it pleases the court, I'll take a seat right here at this table. These are little things, little small nuances of the game that you don't know. Now, they're laughing at him, but the judge knows what he's doing. Nothing comes out of a judge's mouth without some sort of purpose or intent. And he already knows how he's coming, because I don't think this is the first appearance. So he's familiar with him. So he's prepared for him as well. So this should be a very interesting exchange and should be educational as well. Let's check it out.
Mr. Jacobson is personally present and without counsel. Sir, good morning. Were you present in court when your rights were read to you earlier?
Sir, I don't consent to this hearing because of lack of jurisdiction of the court over me. I'm not a 14th Amendment citizen anymore. It's in my documentation that no one ever reads.
Sir.
So right there, you see the laughing again, and you know that somebody added that into there. You know where I got it from. If I could find the original, I edited it out as much as I could. But if I could have found the just original, I would have done that. But because it's not a laughing matter when people are in court trying to enforce their rights. You know, these people act as if people don't have a right to challenge jurisdiction. That is a person's right. Okay, we have a Constitution for the United States of America. Whoever made this laughing, and you may not have taken the time to read it and understand how it is applicable in any situation or the nature and cause of the action or exactly what type of court that you're in. I know some of you don't think that is important. You think everybody's just a judge or everything is just a court. No, we have different types of court. We have Article I courts. We have Article III courts. We have military courts. We have administrators, which are Article I judges. We have constitutional judges, which are Article III judges. That falls under Article 3, Section 2 of the Constitution for the United States. And Article I judges falls under Article 1, Section 8, Clause 9, where they can constitute tribunals that are inferior to the Supreme Court. Now, that principle of separation of powers, it not only plays a role on the federal level, it also plays a role on the state level as well. You have separation of powers. We have legislative courts on the state level and constitutional courts on the state level as well. It's just not on the federal level. All right, so it's a principle that applies here. And the Constitution is put in place to protect us from government. So I don't see what's amusing about an American citizen, private citizen, okay, speaking to a public servant because they represent our interests. We're the ones who allow them to occupy the offices that they do, to question them about something as it relates to the Constitution for the United States of America. I don't think it's amusing at all. All right. Next, all right, you will see that he told him you don't have jurisdiction, and you can see his response. Notice how he just ignores. This is a tactic. Now they're going to use procedural tactics to evade this. It's going to be straight procedure. And this is why it's important for you to understand procedure, understand what an abatement is, how to file certain demands and things of that nature. We don't file motions. A motion is seeking a benefit and a privilege from the court. That is a request. If you're here enforcing your rights, you demand your rights. A demand to dismiss for lack of subject matter jurisdiction, a demand for speedy trial, a demand for a bill of particulars. I need to know the nature and cause of this action. I'm not asking your permission for anything when it involves a right. Permission is when it involves a benefit or a privilege. You're seeking something from the court. But if I'm looking for something, a protection or seeking some sort of protection from the Constitution, it's a demand. All right? So understand that, all right? Understand that. Once again, go to the law library and get you Matthew Bender's forms and pleading book or something. Your state has one. Each state has their own forms and pleadings book. There are many different kinds of forms and pleadings book. It's not just a couple. So that would be well worth a visit to your local law library and locate a forms and pleadings book and look in there. And the next thing you need to learn how to do is do captions of the pleading. Because when you find a forms and pleadings book, it's not going to have the caption of the pleading on it. It's just going to have the body of the document. So you also have to become very astute and understand the correct form of the document for whatever jurisdiction that you're in. That's important for you to know. Okay, so let's get back and let's just see what's going on right here.
I asked you a question.
I told you.
So,
I am not,
sir,
I'm not.
sir,
under your
stop
jurisdiction.
talking over me. I'm going to ask you a question and you're going to answer the question.
I don't understand.
So I'm asking you, were you here when the rights video was
already right here off the offset, the judge is, and he's probably been in a conference with someone, because I went and looked this judge up in North Dakota. You know, that's another thing you should always do. Anytime that you have a judge, do a background check on them. All these judges are public servants, so their information is on the internet. Get on the internet, see what their beliefs are, you know, how what school they went to. You know, it'll give you a good idea of their mindset. I'm not saying, you know, check on them to stalk them or anything like that. But, you know, you want to understand who you're dealing with. Know with whom you deal. That's one of the 48 laws of power. So one of the practices I would always do is I would look up the judges. I'd find out if they're a Christian or, you know, or something else, or whether or not, you know, they went to school. What was their political affiliation, if they had one. What type of clubs they belong to, you know, and just things like that. I try to make an assessment of their mind state. Now, right here, you can tell that he's trying to assert himself dominance over this man and tell him, I'm going to ask questions and you're going to answer, when he should be asking the question, because he's already said you lack jurisdiction. Now, when jurisdiction is challenged, it's not to be ignored. Now, real quick, before we get it deep into that, though, there is something that I do want to talk about, and I need to stress, and it's real good. It's in a document. And I'm gonna read it to you because I think it'll make a good preference to, you know, to the rest of this video. And it's about jurisdiction when you're challenging jurisdiction. Because a lot of people like to challenge. I'm not a real big proponent of challenging jurisdiction right off the bat. I'm seeking some sort of accord and satisfaction or some sort of agreement of the parties. I go into a questioning jurisdiction when they act like they don't know what I'm talking about. You know, they try, well, this is not a civil matter, sir. As soon as they say that, I say, oh, okay, well, there seems to be some sort of mistake. I was under the assumption that this was civil in nature. Okay, so since I'm mistaken, I'm sure that I'm afforded protection by the Constitution of the United States of America, in that I have a right to know the nature and cause of any action. Is that not correct, sir? You're always asking him questions, because if you don't, then you're making a conclusion of law. You're operating under a presumption. Anything you say can and will be used against you. The person who's asking the questions is the person who's in control. You have a right to ask questions because you have constitutional protections. They can't stop you from asking questions, and they can't tell you that you can't talk because you got a Second Amendment right of freedom of speech. I'm sorry, sir, but has the judge made a judicial determination and I'm not to be afforded my due process rights as freedom of speech in these proceedings? When they get all that shut up and all that kind of stuff right there. Equality of the law is mandatory. He's a referee. Obviously, you don't want to be rude. Obviously, he does have a right to make sure that the proceedings are conducted in a fair, equitable, and peaceful manner according to the rules of court. All right, you're not trying to go outside of that, but within them rules, I got a right to challenge jurisdiction, and I got a right to question and make sure that I have a proper understanding of the proceedings. Now, this word understand, this is a real interesting thing about understand. The first time I heard understand, I think it was with Dr. Malachi Z. York. This was in the 90s. And they was talking about when you understand, you stand under something. You know, understand. Well, I'm not standing under anything. That's been out for a very long time. You know, and that's why they came out with the word overstand. I'm standing over something, you know, not under something, over. Now, there is an esoteric meaning to these words, in particular in the English language. When you start studying the English language, you will see that it is it's based off the number 6, which is the number of imperfection. And that's why all the words have multiple meanings. You really don't know. If I say pen, if I just say pen, what am I talking about? What is the first thing comes to your mind? Tell me, what's the first thing comes to your mind in the chat when I say pen? If I just say the word pen, what comes into your mind? Just put it in the chat. Just write what you think when I say the word pen. What comes into your mind? I'm going to wait and see. Pen. The word pen. A writing tool, okay? A writing instrument, a needle, a pig pen, who knows? All right, exactly. All right, you don't know what I'm talking about. You don't know if I'm talking about a pig pen. You don't know if I'm talking about a stick pen or you don't know if I'm talking about an ink pen, all right? Because the word pen. So there's a presumption. You start asking, I say pen, you say, well, look, man, I don't have an ink pen. I don't have anything for you to write with. And you're just answering the question. You just made a presumption. You don't know what I meant when I said pen. You don't know what I mean when I say charge. You don't know. Because when you look in the dictionary, I have multiple senses of the word. So in what sense of the word is this word being used? So you look foolish answering questions in court. You got to learn how to answer a question with a question. And I'm going to see if I can do that with this right here. I'm going to see if I can go with this. But let me show you something. Oh, there it is. Okay. Oh, see. There we go. All right, this right here, this is I'm always showing y'all this document, Don Quixote School of Law, real good. But the introduction to this is so powerful. It's very, very powerful, the introduction to this. So I'm gonna try to, let me see if I can read this to you. I'm gonna put this, so y'all, I'm gonna read this to you. You can find it on SPC University. You don't have to be a member to get it off my website. There is a whole entire PDF download section on SPC University. All you have to do is, go to the title bar, click on PDF downloads, and it'll take you directly to the page. So, comments from the professor on traffic citations and introduction to abatement. We're talking about abatement. Now, an abatement is considered to be what's called a dilatory tactic. And what dilatory means is temporary solution. And what you're doing is you're trying to get them to clear up errors in process. So it's a procedural attack, all right, because they like to skip procedures. Like, they're operating under presumption. They're presuming that you already know the nature and cause of the action. Okay, well, I got to rebut that presumption. Okay, and let's clear up this procedural errors. So let's look what he says. I always thought that this was very educational, which is why when people tell me that they challenge jurisdiction, and this is always in the back of my mind. So it says, there are many that believe that special appearances by paperwork, motions, etc., nullify court jurisdiction. Under emergency powers, this is false doctrine. There is no remedy in challenging a court's jurisdiction except by abating its process first. Abatements are not a challenge to a court's jurisdiction, merely a good faith attempt to correct errors in process. Clear up the errors, judge, and I'll appear. And we know that an appearance means to subject yourself to the jurisdiction of the court. We need to look that word up in a Black's Law Dictionary and stop thinking that's another word a lot of people make a mistake about, is making an appearance. They think just coming in court is making an appearance. Making an appearance is when some sort of action that you take that subjects yourself to the jurisdiction of the court. It could be filing a motion. It could be entering a notice of entry of appearance. Those are things that's how you make an appearance. But an appearance is not just because your body is there. Appearance is some type of action or conduct that you engage in that lets the court know that you've subjected yourself to its jurisdiction. All right, so right here, when we say we're making a special appearance, we have general and special appearances. Special appearance fail when a judge knows what he's doing. Under martial rule, judges do whatever they want, whenever they want, so long as he or she does not alarm the public or disturb the peace. Jurisdiction is always granted to try jurisdictional questions, even if one goes to higher courts. Defendants grant jurisdiction without knowing it because they never challenge the process that creates the jurisdiction in the first place. See Federal Rules of Civil Procedure, subsection 2.424. Process is perfected by appearance, special or otherwise, Also, remember, the court is not the building, the judge, or anyone else. It is the paperwork. If the court paperwork is defective, there is no court and it ceases to exist. The only way to overcome the war powers court process is by abatement. Traffic tickets are a pain for all of us. When using this abatement strategy, first send in a notice of abatement, memorandum of law, and denial of corporate existence to the clerk of court. That generally takes care of the annoying ticket. If you do not hear from him within 15 days, send in a default notice to the notary to the clerk, from the notary to the clerk. If you receive a summons, which has the proper signature of the judge and the court seal, send in the subpoena and discovery interrogatories to the prosecuting attorney and the judge. You're challenging jurisdiction, and the opposing party must reverse your challenge, or the court cannot proceed. In most cases, they will never give you the documents you have requested or answer your questions. They don't like to answer questions. That's the number one thing that you're going to see. If they do, and that's why they're putting out all these videos to make it seem like your questions look foolish. You know, all these people putting out these videos, and you go on their pages and, they're bots and, you don't know who they are. Who all these people all of a sudden suddenly got this keen interest in people coming into court trying to assert their rights. But let's look at it again. It says, you're challenging jurisdiction and the opposing party must reverse your challenge at the court or the court cannot proceed. In most cases, they will never give you the documents you have requested or answer your questions. If they do, you won. The people granted authority to the state legislature to adjudicate only a few matters: actions at law, actions in equity, and actions under the rule of necessity, military. Admiralty was remanded to the federal government, and the states are supposed to have no authority to legislate in this jurisdiction. There was a time when someone aggrieved of harm would file a tort at law. Moreover, the nature of the action governed the rules of the procedure. That's why you need to know the nature of action. If there was a breach of contract, then this was an equity matter. If the aggrieved party could allege a tortious breach of contract, this matter was moved from the equity side of the court into the law side. This is because the people must have access to a remedy at law if this type of action would give relief. If one were in the military or if one were under in the territory under martial law, the court was a military court. If there was a breach of an international contract, the matter was federal and heard under admiralty. The state legislature cannot vest a court with authority that has not been delegated to it by the people via the Constitution of the state. And that is very important for you to understand. All right, they try to pretend like it's not, but these courts get their authority from the Constitution, and the people spoke the Constitutions into existence. So if I'm questioning you on your jurisdiction, it's you haven't let me know. We have legislative courts. They're enforcing statutes. These are not constitutional courts. Constitutional courts will rule on a statute to see whether or not it is constitutional. That's what Article 3 courts do. They're the defenders of private rights. So if you're dealing with a judge in a courtroom and he's there enforcing a statute, talking about code section this and that, you're not dealing with a real judge. You're dealing with an administrator. They administrate statutes for the legislature. They call themselves judges. They look like judges. They walk like judges. They talk like judges. But they're not a constitutional judge. They're a referee. They're a referee, but they're not there to, they don't have the authority. They don't have that right of lifelong tenure and protection from salary diminution. The reason that they have to have that is because that is how a true judge stays unbiased. You cannot threaten him with loss of his job or a loss of his income. They can't do all that's protected because that's put in place to make sure a judge remains unbiased. So if a judge doesn't have that and we're dealing with somebody, then we don't have no guarantee that he'll be unbiased. If he's appointed as a judge or voted in as a judge every 4 years or something, he can lose his job. You get what I'm saying? Especially all you people out there that are new, that don't take time to learn civics, understand how government works within your state. All right, so right here it says the state legislature cannot vest a court with authority that has not been delegated to it by the people via the Constitution of the state. They cannot create a new nature of action out of thin air. Later on, when the constitutions of the several states were amended to recognize and administrate corporations, that's what the 14th Amendment did. It essentially made legal fictions citizens, and a corporation is a legal fiction. That's the status, that's the straw man status that we're talking about. This is also the reason when you look at the Constitution for the United States of America, if you understand anything about grammar, prior to the 14th Amendment, every time you see the word citizen, it's in a capital C. after the 14th Amendment, everywhere you see the word citizen, it's with a lowercase c. This is the difference between a proper noun and a common noun. A proper noun is a particular person, place, or thing, and a common noun can be any damn thing, all right? And that is why it allows, we don't know what they're talking about when they say citizen. So when they ask me, am I a U.S. citizen? I'm sorry, sir, but how do you define U.S. citizen, and where do you derive your definition from? Because it's my understanding prior to the 14th Amendment, there was no such thing as a U.S. citizen, according to Susan B. Anthony versus the United States. Hit them with some case law whenever you can. You got to be able to quote some of those citations of authority, or else they're going to try to call you. See, you got to understand, an administrator works off precedents. And these administrative courts, they work off precedents. That's another word for common law, in case you were unaware. The precedents. Common law is unwritten law. Common law is a body of principles that do not come into existence until some facts have appeared in court, and those facts have been ruled on and stipulated to, and now you can apply those principles to it and create what is called law. That's why they call it judge-made law. If you look up the word judge-made law, you're going to see it's synonymous with the word common law. Look up those words, all right? So, once again, all right? So when they said the state legislature, we're talking about legislative jurisdiction. Understand this, the legislature has a court system too. They adjudicate their own statutes. That's why they do this, because of separation of powers. Separation of powers means that each of the other branches cannot infringe on any powers that have been delegated by the Constitution. This is where they get their word plenary power from. Plenary power. They have which means they're like God within their jurisdiction. Anything the Constitution has given them authority over, they're God over it. They are God over it. But remember, the Constitution, certain things are reserved for the states and the people. And also, we put some restraints on them. They can make no law that will impair the obligation of contracts. They cannot take private property without due process of rights and just compensation. These are limitations that we put on them. The Constitution wasn't written for you. The Constitution was written to create government and restrain government, give them a delegation of authority, tell them what they can and cannot do. And the reason Article 3 judges are there to ensure that they do not encroach upon that. Because what lies behind, outside the Constitution, is called private. If the Constitution has authority, the Constitution is public law. It has no application in private matters. What rules in the private is contracts. This is why this distinction between public and private is so necessary. You will listen to somebody, it really sound like they know what they're talking about. But once you understand what I'm talking about, you can say, yeah, that was pretty good what you're saying, but here's where I think you mess up. Because that's usually the mistake of beginners. They come in with statutes, they start quoting code sections, and then they want to start talking about common law and contracts. They're just mixing everything up. That's one of the rules is public and private don't mix. You can't mix private remedies in with the public. And likewise, you can't mix public remedies in with the private. Both sides have remedies, and you have to decide at the onset which remedy you're going to use. Are you going to use a private remedy or a public remedy? But you can't mix public and private. You cannot mix them. And every time you do, you're going to mess up. So you have to understand that, all right? So it goes on. It says, later on, when the constitutions of the several states were amended to recognize the administrate corporations, a separate court was established, and the action was in the nature of administrative. Live people could not be brought in administrative courts, as the only matter at issue was a breach of corporate charter by an artificial person. Somewhere along the line, the announcement and the complaint of the nature of the action was lost. Karen Hughes got a video on YouTube. I'm going to put it on my channel where she was explaining this, talking about these two constitutions. You see that I've always referenced them too. Yeah, there's a Constitution of the United States. That's the one you see prevalent all over the place. And there was a Constitution for the United States of America. These are two separate things. United States and United States of America are not the same thing, okay? United States is a proper noun. It's the name of something. United States of America is descriptive. It's describing how all the states united together and came together to form a country called America. But prior to that, United States is like Federal Express. It's the name of a business. And that's why it's everything under their purview, which is territorial in nature, which means they have territorial jurisdiction. That jurisdiction is outlined in Article 1, Section 8, Clause 17 of the Constitution. So within that jurisdiction, they have plenary power. The Social Security number is theirs. So when they issue the Social Security number, the purpose of the Social Security number is to take money out of your check to help pay the national debt. They tell you it's for you when you retire, but that's not it. They're taking money to pay 100% of your taxes goes to pay the national debt. Where'd I get that from? From Ronald Reagan and the Grace Commission report. That's probably why he got shot. You can get the Grace Commission report on the internet now. It says, and I'm not going to read all of this, but it would be good for you to read. But this right here is the part I want to bring to your attention. All right, these two right here. It says, I contend that if only 10% of the people enforce their right to know the nature and cause of the accusation, that we could most certainly shut down the incessant stream of revenue being fleeced from the people by these administrative courts. As far as the compelling government interest doctrine, this is clearly matter founded in law, martial rule. The military authority is in the process of returning control to the civil authorities, but has not yet completed the process. Now, I can understand what they mean law, martial rule, because compelling public interest, I don't interpret it like that. A compelling public interest is if you violated some public law. That's why they got to go to warrant. When they get a warrant for you, if you're a private citizen and you come into the public and violate one of their laws, they can come and get your ass. Don't sit there and say that you don't have no jurisdiction over me. What are you saying? As a private citizen, you can come into the public and kill someone? You can't do that. So they're going to go to a judge and they're going to have a warrant, an affidavit from some officer. He's going to swear out a complaint, and the judge is going to give him a warrant and is going to allow you to pick you up. A warrant is warranting that they will pick you up. It's like insurance. They're going to pick you up now. He has the authority to pick you up and bring you into the public to answer for your transgression. But notice, he has decided that's a compelling public interest. The public has an interest in something. Or, if they got to build something and you got private land, and they need to take your private property, they can take it. The Constitution says they can take it. They just have to have a compelling reason to take it, and they got to compensate you for it. Right here, I like this right here. It says, this one you want to commit to memory. I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction, venue, and the nature of the action until the prosecution properly alleges them. I'm therefore unable to enter a plea to the charge until I've had an opportunity to raise a meaningful defense against these elements. I cannot rebut an unstated presumption. That's one well worth sticking. That's the one well worth putting into your hat and committing to memory. This is something that you say at arraignment. How do you plead? Yeah, I'd be more than happy to enter a plea into the record. But before that, I must, if it pleases the court, you say, I'll be more than happy to enter a plea into the record. But before I do, Your Honor, if it pleases the court, I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction. You see how I did that? Just have you some kind of way or some type of open, just be prepared to go into this. It's called ad-libbing. If you rap, you know what I'm talking about. When you remember something so good, and now you can just ad-lib with it. You ain't got to think about it. You comfortable, and you can keep it flowing the way you want to, but you ad-libbing in things. That's how you want to get with this. You same thing. You want to be able to memorize it to a point where now you can flip it, change it around, ad-lib with it, mix it in with other things you be saying. The next thing you know, you got an arsenal. Next thing you know, you got a whole a full metal jacket of information that you can start busting at somebody when they come and challenge you. All right. Let's get back. I don't want to digress too far, but I did want to kind of make you aware of that about this challenging jurisdiction that people like to do. A lot of the times it's because he's going to be bringing up his excuse. You didn't properly lay it before the court, meaning that you haven't followed the correct procedures so we can establish a proper venue to address that. You're sitting there saying that the court didn't have jurisdiction, but he said he put in his paperwork. I haven't seen his paperwork. I don't know. But a lot of times, what he's doing right here is he's trying to assert authority over him right now. You got to pay attention to these little nuances. 90% of communication, a lot of times, is not what you say. It's the body language and the underlying thing, but the reason behind something too, why something is being said. Like, do you have a job? That's not an innocuous question. You know, how you answer that question, the judge is going to take silent judicial notice of the fact of whether or not he does have jurisdiction over you. Oh, you got a job? This nigga's crazy. I don't know why he came in here talking about I ain't got jurisdiction over him, because I know you got a social security number. That means you using it too. If you got a job, you're using the social security number. Don't come in here and say that you're not a 14th Amendment citizen and you taking a benefit and a privilege. We got Ashwander Rule number 6. The Ashwander Rules. Read number 6. Let's get back.
Played not once, but twice this morning.
I was here.
Do you understand the rights as they were read to you?
I don't stand under anybody.
I'm asking if you understand the rights that were played for you.
I don't understand.
Okay. So let's talk about what you do and don't understand, sir. Do you understand the English language?
You do not have jurisdiction over me. If you look at the documentation,
Answer my question, sir.
you do not have jurisdiction over me.
Answer the question, sir. Do you understand the English language?
I don't understand.
Okay. So I'm asking you if you understand the English language.
I don't stand
So-
under anybody.
Sir, I'm asking you if you understand English. I asked the question in English. You responded in English.
So
I think you
what's
understand,
your answer?
but I'm making a record, sir, to make sure that we're clear.
My record is you don't have jurisdiction over me.
And,
I'm not a 14th Amendment
Sir.
citizen or resident.
sir,
You even know what I've done? I've changed my jurisdiction. I've gotten out of the jurisdiction of the water and I'm back on the land where
sir,
I'm alive. I'm a living, breathing soul. And you cannot contract with me anyways.
Okay. This I don't suggest. You can do what you want to do, but I've seen this too many times, you know. All right. Obviously, we're talking about admiralty. He said, I'm off the water and I'm back on the land. I don't know if you say that because admiralty jurisdiction is the law of the sea, but it doesn't have to do with the locale. It has to do with the subject matter, and the subject matter is commerce. Now, if you want to know where I got that from, I got that from studying the history of it and John Hall's the clerk's praxis. And there he explains that. And also, if you read the Secret Jurisdiction, the Maritime Jurisdiction Exposed, they got a battery of case law in there that shows you how the admiralty applies to the sea as well as to the land. Because they're going to try to say, well, this is that law of the sea stuff. And I understand it is the law of the sea, but you haven't studied the subject. When you start studying the subject, you get to understand, okay, I see what they're doing. It's colorable. That means it's not the pure admiralty. They had to make all the laws colorable because there isn't any money. There's no money. You can't have a real law and fake money. So they had to make a colorable jurisdiction to facilitate colorable money. So everything that they're doing is an imitation of something. It's an imitation of something. So that is what we're getting at. That's why it is the land of legal fictions. It's dealing with legal fiction entities. These are all legal fictions. It's all you can't mix public and private, so you cannot have a corporation go against a real person. That's something else. A corporation is a damn construct of somebody's mind. It's a figment of somebody's goddamn imagination. And you're going to tell me that it has a claim against me? Oh, I get it. It's a representation of the people. It's still a legal fiction entity that has not been injured. It can't swear out a complaint under penalty of perjury. You're there if you're an attorney, you're there representing that interest. But I don't see how a legal fiction can have any interest over me. I can see how a legal fiction can have interest over another legal fiction, like two corporations going at it. And would it be reasonable to assume, since you're telling me that corporations can be citizens of a state, that according to the 14th Amendment, when I see that word citizen and it's in lowercase, that was a way of that allowed corporations to become citizens. So I should ask the question, well, why would it be beyond the realm of possibility that all caps name is a corporate created entity? Why is that incredible? I see attorneys all the time incorporate their name. Why is that so incredible? What is the definition of an individual according to Title 26 in the United States Code? How it's used in the tax law, because this is all taxing. These are some of the questions that we want to know. These are questions. They're just a couple of questions. It's all just questions. Nothing serious. You know, why when I ask a question, you get upset? I can see some of you right now watching me, and just me asking these questions is pissing you off. And you got to ask yourself, why the fuck are you pissed off? I'm just crazy, huh? Either that or you are not as intelligent as you think you are. Let's keep looking at this and see where it goes.
I'm not contracting with you at all. I'm asking you if you understand. Sir, stop talking out of turn. Are we clear? I'm asking you, do you understand the English language?
You've answered that already.
So your answer is yes, you understand.
You answered it.
I'm asking you to answer it, sir.
You've answered it yourself.
It's not for me to decide. It's for you to put on the record whether you understand the English language or not. Do you understand what I'm saying to you?
I don't stand under anybody.
That wasn't the question.
We're not going to get anywhere. You do not have jurisdiction over me.
Sir.
If you agreed.
Now, this is a point that I see all the time that comes up in videos like this. He's absolutely correct. When you challenge jurisdiction, that has to be addressed. You just can't, and that's one of the number one things they do. They all in unison like to run over that question right there. If I'm challenging jurisdiction, we do have a constitution for the United States of America. And now what's going on is a game of acquiescence. Silence is acquiescence. So if you give in, then you acquiesce. This is why in dealing with presentments in chapter 4, he says sometimes you have to do it 3 times. Because the judge needs to be sure that you're taking it. So he's going to ask him at least 3 times. You got to be aware of that. You may have to say something to him 3 times. He'll ask you something 3 times. All right, so the record is set, okay? Because that constitutes, that settles the matter. All right, but what would probably be a better approach would be, Your Honor, before I answer any questions for the record, I think there's a few jurisdictional issues I need to be clear on. Wouldn't you agree, sir? Before I start making a record, I need to understand, that so I can understand the procedure that we're operating under, because that there are different jurisdictions with different procedures. So is this a civil or criminal action, sir? Just go right into it. It's a criminal action. Thank you. Let the record show that the action being brought against the defendant is a criminal action. Now, sir, I have another question for you. And you get into that, and he's going to probably try to interrupt you. See, so you got to be ready for interruptions. They interrupt you, and they're trying to dominate you, and it's like all equal under the law. You're asking a question. You're not in the wrong, so you have to understand, are you in the wrong for asking a judge what jurisdiction are they operating under? Are you wrong for that? Are you out of line? You have to be firm in your conviction on that point, because that's going to be the matter of contention in court when you're going back and forth with this man and you asking him what jurisdiction he's operating under, and he's not going to want to tell you, because that's the ultimate secret of the courts, not to tell you that information.
If you had read my affidavit.
Were you present in court when your rights were read to you earlier?
I've been in court many times, and I've heard those rights.
And so you understand those rights?
I don't stand under anybody.
That wasn't the question. Do you understand?
That's what you're asking me to do. I don't stand under you.
Sir, You've already said you made a special appearance. So I'm asking you if you understand. Do you understand?
I comprehend them.
Okay, comprehension is good enough. You comprehend them. All right. Do you comprehend that you have the right to an attorney?
I don't need an attorney.
Do you comprehend that you have the right to either an appointed attorney if you financially qualify for one, the right to hire an attorney of your choosing, or the right to represent yourself if you can do so knowingly, voluntarily, and intelligently?
I don't consent to this hearing because I'm not under your jurisdiction.
What the judge is doing now is conducting what is called a colloquy. A colloquy in court is when the judge engages you in dialogue to make a determination about your level of competency, whether or not you're competent enough to represent yourself, because that's what you're doing, because the Sixth Amendment also protects your right of self-representation. So that is a constitutional right, but you got to be competent enough to do that, because it is the duty of the court to ensure that you do get proper representation, before you go to trial. So right now, this is a procedural thing. The judge is not really out of line. It's a little technique he's using. They follow procedure. He's trying to circumvent something. Well, look, let me get on the record first that you are competent. Let me make sure I'm competent with the person I'm talking to. He also mentioned that he said, look, man, you've already said you made a special appearance. All right, so he just confirmed on the record, I understand that you're challenging jurisdiction. So, we can let that go since he said that. Since you said that, for the record, you've already made it. You've already said for the record, you have that you're making a special appearance. So that was an acknowledgement. So I would have, proceeded forward after that. Just kill that matter. Let's go. That's what he's saying. Just kill that. Let's move forward. So let's see where it goes.
Sir?
I'm in the jurisdiction of the land.
I
Not in
understand.
the jurisdiction of,
Sir?
of your contract law.
Okay. Do you comprehend your rights to an attorney?
I don't need an attorney.
Has anyone threatened you, forced
No one has
you?
threatened me.
So let me finish before you start talking. Sir,
I've been here the last 7 times.
stop.
Nothing has happened. Read
Stop.
the file.
Stop. Sir. Stop interrupting. Stop trying to talk over me. I'm asking you a question.
This is going to be This is one of those important points that people need to understand. He said, I've been here 7 times. You will have a lot of court dates. I had a case, I've had as many as 40-something court dates scheduled. All right, when I first started with this. So I call that fatiguing you into compliance. There's a chance you could miss a court date and then they can issue a warrant for your arrest. One of the things they like to do is get you in jail. When they get you in jail, they ain't gonna bring you in that courtroom. They're gonna do what is called dry runs. You won't get into the courtroom. You're gonna be dependent on people to send you paperwork. They're gonna be blocking a lot of the paperwork, not letting you get a lot of time in the law library. When you go into the law library, ain't really no books in there. It's a computer. Very, very minimal supplies in there. A lot of case law, they just want you reading case law and precedents. That's all. Nothing there to really teach you and give you a general understanding of what it is that you're doing, like legal encyclopedias and things like that. So you're going to be put at a disadvantage, is my point that I'm trying to make. They wait for you a slip up, for you to keep. That's why you should go and try to settle and close the matter. The judge is a hearing officer. He's there adjudicating an accounting. That is really what's going on. And they got an accounts receivable that is aging on their books that they're looking for. This is commercial. Remember, always remember this is commercial. What he's doing, he's not addressing the commercial nature of it. He's just telling you, leave me the fuck alone. When you do secure party, we're looking for an agreement. We're there to honor the court. We're there to settle the books and balance the books and settle the matter. So it's a different approach. I'm not saying one is better than the other. I'm just saying as a matter of fact, I absolutely don't feel that one is better than the other. They both have their purpose and they both are effective, So just know that that's a different type of thing that's going on. But they both are based off the fact that, hey, I'm not a 14th Amendment citizen. The 14th Amendment, a citizen was created under the socials, came into effect. Y'all applied it to us. When you got the Social Security number, made us a federal citizen. after 1933 under Franklin Delano Roosevelt's administration. Okay, he was the creator of the welfare state. You can get on the internet right now and just put in Franklin Delano Roosevelt, the welfare state, and read about it yourself. Everybody in the United States of America are welfare recipients if you're using that damn Social Security number. That Social Security number is why they call you a surety for the national debt. And I don't know how they want to operate acting like the bankruptcy don't affect things how it operates in this country. I know you don't want us to believe that either. You $32 trillion in debt. Everything you're doing in this country is to address that. Including while you locking people up and giving them traffic tickets and all this kind of thing, all this kind of stuff. All right? So let's get back.
Has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive your right to an attorney?
No one has.
Thank you. So we are here today for a number of dispositional conferences. A dispositional conference is a conference set to determine how you intend to proceed.
Your Honor, if I could interject, I'm sorry, but I think there's a little more complexity to this procedural posture. In case 16, the defendant had filed a motion to dismiss. The motion to dismiss, a response was filed with the state on June 28th. At the last status conference, the defendant wished to raise the same motion in all three of his cases.
Okay, right there, I got a problem. He filed a motion. When you file a motion, you granted jurisdiction. She bringing that up for a reason. That's being brought up on the record for a reason. That's not being brought up on the record for no reason. Oh, he filed a motion, Your Honor. He's seeking a benefit from the court. How is he saying he's not under our jurisdiction and he's seeking a benefit from us? You're there talking about your rights. I don't request my rights. I don't request my rights. I don't request my rights. Not from the court. You know, you might have to request it out in the field when the police trying to beat you over the head or got a gun pulled on you, you know. Pick your battles, but in the court on the record, come on, man.
At that time, it had not been served in the two remaining cases. Although the motion still has not been served, it has been filed in the two remaining cases. And so I believe that there is a pending motion before the court in all three cases.
So this wasn't noticed as a motion hearing. Rule 3.2 requires that the moving party file a notice of motion declaring whether or not the motion is to be heard for oral argument, to be heard for an evidentiary hearing, or to be considered under briefs. That notice of motion wasn't filed, requesting a hearing. So today it's not properly before the court, even if it was properly served.
I brought it to the court. I couldn't.
Okay, okay, you know, he said you had to have a notice of motion. And, you know, in that notice of motion, you have to specify exactly what it is that you want to, you know, to discuss. And he's going off procedures. See, right now, he's hitting with the procedure. You've raised an issue. He already told, you know, you didn't file these motions. Okay, well, if you're going to address these motions, this is the way those motions have to be addressed. You the one filed them. You the one filed them. That's what it is. Like, what are you talking about? You filed a motion. If you file a motion, this is how, according to the rules that have been laid down by the legislature, okay, the state legislature, he's just an employee. He's an employee of the state legislature. Okay, he's under the legislative branch of government. He's in there acting as an administrator. He's doing a ministerial duty, which means he's following directions. because that is the constitutional protection for them when they follow procedure. That's how they protected by the Constitution. They follow procedure. So you have to look and see what you're doing too. You got to look and see what you're doing. You know, you got to, this is a game of chess. And, you know, they playing with you and everything. They making moves and you ain't understanding their moves. You just want the shit just to go away. You know, just leave me the fuck alone. Why are you fucking with me? I understand. They should be. But they have a right to operate under a presumption, especially when you do moves like that and file motions into the court. So just saying.
Not get hold of Mr. Hughes, you would not
So,
return my
stop.
calls.
This is where I'm talking. So those motions have not been served. So technically, even if the states filed a response, they're not ripe for the court's consideration. So the court is not going to take up motions. Furthermore, these are Judge Naram's cases. I'm not going to rule on motions in Judge Naram's case or cases that are not properly before the court and noticed for hearing. So as far as the court's concerned, all that's before it today properly is a dispositional conference. Sir, you have 5 options at a dispositional conference. You can schedule it for a jury trial. You can request a bench trial. And if the prosecutor agrees and the court agrees, the court can schedule it as a bench trial. You can request a continuance. You can change your pleas from not guilty to guilty today.
What you're witnessing right now is the judge. He read all that stuff off. This judge is nice. I'm not even gonna front. You know, I'm just sitting here listening to him. He's nice with it. You know, he's on point with the procedure. I'm just, you know, I have respect for these dudes. You know, I don't have no, you know, like that's why I love the law. I love the law. I love like listening to litigation and arguments and you know, and how the judges, I like reading Supreme Court opinions and seeing how the judge, you know, ruled on a case. All those things are very, very interesting to me. And, you know, like Supreme Court justices, in my opinion, they legal geniuses, some of them. You know, you can read they, you know, and I like brief. I'm like, damn, man, this man right here is bad in the motherfucker. I see why he's a Supreme Court justice. You know, once you get into this, you can really appreciate, you know, a person who has a strong legal mind in some kind of ways. And right here, I'm just like, I'm looking at the moves he's making based off the fact that he filed a motion with the assistance of the prosecutor and put that on the record. And, you know, he's already taken silent judicial notice that he got jurisdiction over you based off of your actions that you've taken. That's on the record. And now this is, if we go into, you know, the issues that you're trying to broach now have not been properly brought before the court. So we're in a disposition conference right now. Here are the 5 things that you can do. That was nice. That was nice. But when you understand how the game is played, then you can understand how to, like, you know, it's chess. Who are the chess players out there? I'm a chess player. So I'm a very good chess player. So, you know anything about chess, when you play somebody who's a good chess player, it gives you a respect for them because it's always an indicator of their level of intelligence. You know, when you meet somebody who's a very good chess player, it automatically forces you to have respect for their intelligence. That's why people love chess, because it says a lot about you. You know what I'm saying? If you're real good and then you meet somebody better than you, and you'd be like, this motherfucker right here is intelligent. Because it's a way of reasoning and logic that's required for the game. The mind has to function in a certain kind of way. And it's the same thing with this right here. And you got to learn how to see how that line of thinking works if you want to counteract it. You know.
Or you, lastly, can choose to schedule a change of plea for a later date.
Well, let's do a continuance until Judge Naram gets the case so he can make a decision on it.
All right. So what I told you before is right now, those issues aren't properly before the court because they haven't been served properly following the rules.
Serve them properly, we'll just do a continuance then.
All right. Ms. Depute, your thoughts?
that seems appropriate to me. I believe at the last, maybe there are not notes in the docket. I believe it was contemplated by the previous judge that this would be a motion hearing. It was discussed at that time. The state is ready to proceed, but if Your Honor doesn't wish to hear it today, then I believe continue it until Judge Narum could hear the motion would be appropriate.
So, okay.
Could you make a decision before you even go back to trial? I suppose I have to file that.
Yes. So Judge Narum's next court date in McIntosh County is 6 weeks away.
That'll be fine.
It's November 13.
We can't get nothing done if there's another judge here. Gotta have Judge Aaron.
Well, he's assigned to these cases, and typically once a judge has been assigned, unless there's an agreement or stipulation between the parties, I'm not going to sign a motion or consider a motion that wasn't on the docket as a motion hearing. So I will continue this matter, all three matters, for a dispositional conference and a motion hearing for November 13, 2023, before Judge Narum. It'll be set at 9:30 a.m., but I'm sure Judge Narum will call that case last. Just so you're aware of that. Mr. Jacobson, it probably will be late morning before that.
Whoever edited the video put the laughing in there when he said he'll call the case last, but that's how they keep all of this out of the public eye, by calling it last, or at least before the video conference. I don't know how they're going to do it now. That's why they had to make these videos, to make people look crazy, because when they started doing these video conferencing, now they can't hide it. But you know how it was done is they would always wait till the courtroom is clear before they would, bring you in and then start, engaging in these matters. You go last. So he said, you're going to go last. He looked at him, and he's not going to rule on it because he hadn't been assigned the case. He was just there in case there had been an agreement of the parties. Both sides reached a stipulation, and then he probably could adjudicate it. But since he hadn't been assigned to it, he's kind of just staying out of it a little bit. He's like, look, hey, there's no stipulation. We'll do a hearing on such and such a date on the 13th. Got some time to prepare for it, Do what you need to do. If you got a notice of eviction, I don't understand. What, did somebody foreclose on you? If they foreclose, you miss court dates, what happened? Why are you getting evicted and ain't went to court would be my question. Are you asking me how to answer a court or a notice of eviction? If it's doing with something about money, I'm going to use the Fair Debt Collection Practices Act. I'm going to use that to respond to it and require they verify debt. It just depends. I don't know. I don't know what you mean when you say that right there. There's not enough information.
Motion is heard. Ultimately, Judge Narum will be able to decide the motions, assuming that they are properly before the court at that time. And so that means proper service, proper notice of motion. You'll need to file a 3.2 notice of motion that declares whether it's for evidentiary hearing purposes, oral argument hearing purposes, or both. And at that time, Judge Narum can make decisions. So that'll be the decision of the court today. Continuance in all three files until November 13 before Judge Narum at 9:30 a.m. Anything else, Mr. Pugh?
To clear up part of the record, in case 16, it was noticed as a motion hearing. I understand the judge's ruling. I just want to make sure that what's represented is correct. But other than that, I have no further comment.
Yeah, because I remember him telling me to file motions for the other three, put them all three on the same day.
Yeah. So as a matter of judicial economy, even if it's not an odyssey. The code that I was looking at isn't an odyssey saying that it was a motion hearing. But the notice of hearing document does say and motion hearing. But in the odyssey record, it just says misdemeanor dispositional conference on file 16. On the others, it has not been cleared up. So in the interest of judicial economy, those will track together if it's the same motion in all three files. So All right, with that, we're adjourned in this matter. Thank you.
Okay, right there. I thought that was a good video. That was a good judge. You know, in my opinion, he was very professional. I think he handled it. I think he handled it admirably. You know, just based off the mistake. You know, the person who came into court, he's the one that gave him an opening like that. He did not address the challenge to jurisdiction, which I think, you know, should be able to be done orally. But it's just the fact that he filed a motion. He said, well, you filed these documents right here. So that's just, you know, now that's not my, you know, I'm not definitively saying that's the reason. But, you know, I think when you start looking at everything, when you start talking about jurisdiction and understand how jurisdiction is obtained over people, you'll probably see, you know, where the errors lie. So let's look at another one. I got another one I want to check out real quick. Let me pull this one up. This next one I'm about to do is a classic one. It's been on the internet for quite a while, but some new people may not have seen it. So I think it is my job to share it with you. And let's see if I can get to it. And y'all probably have seen this before. All right. Let's check this out real quick. This is a classic, but I want you to listen to some of the things that are said in this video and some of the things the judge says as well.
No. All right, sit down, please, sir. Just Keith. Pardon? Just which? Keith. I'm here to correct a mistake by the court and by the state. Well, first of all, if the court has made a mistake, are you Wilfred Keith Thompson? No, that's not what I normally go by now. Can I see the information? That's a fictitious affidavit in terms of person legally speaking, sir. I've tried to clarify this a few times, but apparently the level of incompetence.
So your name is Keith Thompson?
My name is Keith, that's all. Nothing more, nothing less.
You don't have a last name, sir?
I have a family name, clan name, but that's irrelevant today.
So you are not Wilfred Keith Thompson?
Okay, one more time on and for the record, I am Keith. Nothing more.
And sit down, sir. I'm looking for a Wilfred Keith Thompson. Please sit down, sir.
Actually,
Please sit down, sir.
Sorry. Can't do that. I served into the court this morning.
Sir, I'm looking for a Wilfred Keith Thompson. You are not that
This is
person. Sit down, sir.
Bailiff,
Please remove this gentleman from the courtroom.
Thank you. That's the person you're looking for.
Please,
Sir, that is the person. I'm trying to remedy things. Touch me and you will be charged. I'm a peace officer. You want to dishonor a court official?
The defendant's on the bailiff's desk.
Sir, are you here on behalf of Mr. Thompson?
I said I was the administrator to that account.
Are you here as agent for
Could you
him?
guys please back up? Thanks.
Are you here as agent for him?
Not as agent.
No, right there, that's what I want you to say, where he asked him, are you here as agent for him? This was the root of, started a little movement where he was they started looking at you as the agent for the straw man, like the resident agent, you know, of a corporation. You got to have that, you know, if you're going to form a corporation in another state, they need a resident agent there that you have to put, who is that person? And that's what you're looking at. The straw man is supposedly a corporation. So are you, you know, the registered agent? I said resident agent, registered agent for it. The registered agent for a corporation in a particular state. you know, the registered agent is so they can receive service of process and things like that. Well, likewise, that's what people came up with this. It was a real big video, audio I put on my radio show, and the dudes just ran with it, saying that you are the registered agent for the straw man. And they used that approach to it and sought to get a declaratory judgment against it. It's a really interesting process. Definitely something that is well within, you know, the principles and theories that a lot of all this stuff is based on. So, you know, I can't say yes or no to it. But, okay, Keith Thompson here, Wilfred Keith Thompson, judge told him to sit down. The officers came over. They ain't supposed to put their hands on you. That can be assault, you know. But, you know, he tell him to move him from the court and, you know, all this kind of stuff. And but you see he's still standing there. He served him with papers. And he says he's a court official. I don't know where all that came from. I've never really seen it. I've never really seen anyone use it other than him. I have gotten pretty sturdy with people in the courtroom before. And that's why, you know, I'm always impressed with this video because, you know, the level of, you know, how assertive he was. You know, he had the right, I think, attitude, disposition, but, you know, he kind of at times, I think he was riding that line and kind of tough. But let's look at it. Let's see what goes. Let's look at it.
As administrator, much like you are administrator of this court.
Sir, you're either him or you're here as his agent. You speak on his behalf. Are you either of those?
Yeah, it's lawful.
Pardon?
Yeah, he's in common law jurisdiction, which I established as soon as I came in here this morning and reestablished again. The bailiff understood me. This other bailiff, wherever she went, she understood me as well. And this gentleman doesn't like talking.
We're going to take a recess. Thank you.
Thank you. All rise.
How long?
How long, sir? I don't have all day, thank you. I have things to do.
We'll take the court.
Yeah, actually,
This court will recess
please note that the judge has abandoned the court. He has abandoned ship, and I, as the sovereign in this room, claim authority. Case dismissed with cause and prejudice. Have a nice day. See you later.
I'll start making my way down from
That's great.
In my bag.
Hold on, his bag.
His bag.
Hold on, his bag.
And my water, please. Oh, I need my birth certificate. And you grab the BC.
It's on his desk.
Okay, that's the original.
Well,
Okay. Yes. Actually, Ann, leave it there. Leave it there. So put it back in the bail. Thanks. They've got the real thing.
You can get that back.
No, it's in there.
Could have been that easy.
Anywhere in a court. Argue with them.
As soon as I came in here this
Okay, it was about to go off. I wanted to comment on some things here. Okay, now, a lot of people talk about the fact that the judge just very strangely, when he started talking about common law courts and establishing common law jurisdiction, the judge stood up and bowed to him and walked out as if he was conceding to him or something. And then he, as a sovereign, took over and declared the matter over with. I don't know what happened after this. You know, I can't say, but this is like a video that's been on the internet for a while. And I just thought it was very, very interesting to kind of look at. It was just did seem to be some very strange things that were happening in here. You know, how he stood up and bowed to him and then walked out. And then, you know, it was just interesting. It was, I'm not saying it means anything, but just watch.
again. The bailiff understood me. This other bailiff, wherever she went, she understood me as well. And this gentleman doesn't like talking.
We're going to take a recess. Thank you.
Thank you. All rise.
How long?
How long, sir? I don't have all day, thank you. I have things to do. Let's get on with.
We'll take the court.
Yeah, actually,
This court will recess
please
until
note that the
recalled.
judge has abandoned the court. He has abandoned ship, and I, as the sovereign in this room, claim authority, case dismissed, with cause and prejudice. Have a nice day. See you later.
Now that falls under the 10 principles of commercial law, which is he who abandons the field first loses by default. And that is the principle that they are operating off of when he made that statement. He's abandoned the ship. Obviously, we're talking about an admiralty jurisdiction. If you don't think it's like this, you know, it's a real interesting thing. Anybody ever seen the federal court in Miami? Federal courthouse in Miami? I just thought this was really strange. See if I can pull it up real quick. And you can see right here, this is built like a ship. You know, the damn courthouse built like a ship. Look at that, it's a damn ship. It's a ship in a dock. You know, I saw that, I'm like, and then if you see the grass was cut like water. So it's like they're taking you on a ship. And I just thought that was just really interesting that they would do that. Not saying it means anything, but I just thought it was just interesting. You know, it's breadcrumbs all over the place when you do this information. That's what you have to follow. That's what everybody's following. They following the breadcrumbs, the little signs that you see here and there. And they starting to fit it together like a puzzle, and it's creating a real big picture of actually what is going on. And so the American people, the first thing we have to establish is, are the American people sovereign? What does it saying sovereignty mean? Or are we talking about popular sovereignty, where all of the people of a state's sovereignty is vested into government? You know, like we lose our sovereignty and we join a social contract where we do agree to give up certain rights. I can understand that. You know, I can understand, but what type of jurisdiction are we talking about? Are we talking about some sort of commercial jurisdiction? Are you assuming I'm operating in commerce? Because if you're assuming that, then okay, I'm agreeing, and I'm doing that. I don't have a problem following your rules. Because well, why don't you tell me the nature and cause of the action and give me fully informed consent, and then we can move forward. That's what everybody's saying. That's what everybody's saying. You know, it's like, you know, what kind of jurisdiction are we living in? Not just what's in the courtroom, that we living in society. And if you look around, everything seems to be connected with some sort of corporation. Everything is operating under corporation. You see that video footage on YouTube, is the world is a corporation. Network is a movie, came out in 1977. You should watch that. There's a speech the dude gives in there. He said, we don't have countries anymore. He said, the countries now are corporations. The United States of America is a conglomeration of corporations. They make moves for corporate interest. United States have an interest in things. You know, they are operating as a for-profit business. Don't they give it to you, government services? Where is that in the Constitution? Where is all these welfare programs in the Constitution? How are y'all able to offer us Social Security and welfare and, you know, just things like that? You know, where is that at in the Constitution? Where did that? How was that power given to you and interpreted in the Constitution for the government to operate that way? We in a free country. United States of America is a free country. A free country means you as private citizens are responsible for everything for yourself. You're responsible for feeding your children. You're responsible for, maintaining your property, protecting your property. All of that is on you. That's a free country. But, if you choose to come into a commercial district, okay, and operate there, they have the right to presume you're some sort of merchant, and they can attach some sort of merchant law to you under the guise of something called civil. Remember, we're talking about colorable admiralty jurisdiction. It's colorable. And that's why it's important that you learn history, because when you know history, you can look in their statutes and see where they got it from, but they're not calling it that anymore. You know, like here in Georgia, I can read Title 18, which is creditor and debtor, and read a clerk's praxis and see the similarities down to the bonds that are being used in it. Almost identical in some cases. I'm like, wow. But they're not calling it that. They call it creditor and debtor law. So that's why it's important for you to study history so your eyes can see, you know, be perceptive to see what's in front of you. But if you don't study in history, you don't know what's in front of you. You think all these people just made this up yesterday? Hell, you got the Bible's 2,000 years old. And when you read Matthew 5:25, it says, agree with thy adversary while you're on the way to court. At least he hand you over to the judge hand you over to the bailiff, and you be cast into prison. I'll tell you, when I come out until you pay the very last penny. That was written 2,000 years ago. The law merchant is old. This ain't new. They operate in the same way. It's just been modified. It's just been modernized. It's been modernized. They don't let you know, they put you in jail, but they don't tell you, they don't let you know that that you in there for a debt, like a debtor's prison. They write a bond on you, and that bond is being traded somewhere. And then they put your body in jail. You're being held. This is what they used to do with the statute merchant. Matter of fact, let's look at it real quick. Let's look at this real quick. Let's see if I can pull this up. Go over into SPC University real quick. And let's go in our dictionaries right here, SPC University. Go to the dictionary. This is what you have access to when you have a membership on my website. All right. So right here, these are all the legal dictionaries. You know, I got them up to I think the 9th edition in PDF format, 1 through 9. I got a lot of Bouvier's, a lot of different dictionaries, a wide variety of dictionaries. And, you know, your dictionaries are very important. So right now we're looking for statute merchant. This is a real interesting word. This is something for you to study, because what it does is it gives credence into what I'm saying, because you can see it was actually done before. All right, it's not something I'm just making up or pulling out of my ass. You know, you always want to, verify some things that people are telling you. So we go into this. All right, so there's statute merchant right there. Now let's read this real quick. It says, one of two 13th century statutes establishing procedures to better secure and recover debts by, among other things, providing for a commercial bond. I want you to remember that word commercial bond. As a matter of fact, if you got an old case and you need to look at your paperwork and see a commercial bond is listed in there, or get a copy of the docket sheet and say that they entered a commercial bond, because they did. They was doing. I've looked at plenty of discoveries. You know, this is just like I said. Remember I said the breadcrumbs. Well, here's an example of the breadcrumb. Okay, they're establishing a commercial bond. So let's read it again. It says one or two 13th century statutes. Now we're talking about a statute. So we're talking statutory law. Okay, establishing procedures to better secure and recover debts. All right, so it's all about debt collection. By, among other things, providing for a commercial bond. All right, so they make a bond that, if not timely paid, resulted in swift execution of the lands, goods, and the body of the debtor. Okay, these statutes were repealed in 1863. Okay, of course, those were. But look at the second sense, the commercial bond so established. Okay, so when we come into the courtroom, we're asking them for the bid bond. All right, what we're asking you for is this bond right here, that the statutes are cross-indexed with amounts. Obviously so, because some statute violations have what? Penalties that, have fines and everything attached to them that are so you can't deny the fact that there's some sort of pecuniary interest associated with statutes. All right. And anytime we know as a principle of law, anytime another person owes another person any money, express or implied, that creates a debtor-creditor relationship. That's a debtor-creditor relationship. All right. So now debtor-creditor law applies. Debtor and creditor law is what's under the admiralty. I can't help it if all the pieces fit together like a perfect puzzle. So we're talking about, let's keep looking at this right quick. Let's see what the experts say. It says, it is not a little remarkable that our common law knew no process whereby a man could pledge his body or liberty for the payment of a debt. Under Edward I, the tide turned. In the interest of commerce, a new form of security, the so-called statute merchant, was invented, which gave the creditor power to demand the seizure and imprisonment of the debtor's body. See, today you're not supposed to be able to be put in jail for a debt. I don't believe that's so under penal statutes, because I read an opinion of an attorney general in the law library one time in Georgia where they said that you can't be put in, they were talking about child support. Because why are you putting people in jail for child support? Well, they're saying, well, we're not putting you in jail for child support. We're putting you in jail for contempt of court because you failed to follow a court order, which stands to reason that I should be able to come into court and say, well, Your Honor, to the best of my ability, I wasn't able to follow the court order. It wasn't my intention to not follow the court order. Because isn't it everything about mens rea? For you to be guilty, the mind must be guilty. There has to be some sort of criminal intent. So if I have the intention, how are you arresting me? Just something for you to think about when you go into the courtroom. All the people worried about going to jail because they're not supposed to put you in jail for a debt. At least that's what they say. Now, they say a lot of things, but they say a lot of things. All right, so let me read this again. I already read it. So right there, that's what the admiralty was about too. So when you go and study this and you go start studying this, look into their statutes and then you'll see the similarities. You'll see the principles that are being used, the same principles that are being applied. And then that's when you can come to the conclusion on things. This is how you reach a conclusion for yourself. You got to apply, you got to study this yourself. You can't depend on somebody else. Somebody mad at me for the last video I did. I wasn't trying to denigrate anyone. That's not my intent, because I have respect for anyone who goes into court and defends himself or even attempts this. What I'm saying, though, is I do have to, speak on the matter that they are creating a lot of videos on the internet where people are looking foolish. Okay, and that's what I'm trying, that is what I'm really talking about more than anything. It's like you got to properly prepare yourself. You can't just lazily go in, I'm gonna read something from a script and go in there and just say some words and hopefully I'm gonna get off. That's not, I don't even understand where the expectation of that comes from. I don't even understand that. I can't even understand it. Why would even think like that? It requires you have to study to show yourself approved. So if you're gonna do it, I'm not gonna be here forever. Somebody's coming next, behind me or whatever. And it's, it's like, you got to be that person, though, got to be well read, well studied. It can't be somebody coming in just doing stuff because somebody else told them to do it. It got to be the kind of person that conducts their own research. Because let me tell you something, you'll start conducting your own research once you reach a point where you know everything that the people you're listening to on the internet know. You say, okay, he's not telling me nothing new. He's not telling me nothing new. This person over here not telling me nothing new. Now, the only other avenue for you to go is to start doing your own research. Start reading some of these historical books. Start reading, and then you'll start seeing things. And that's going to make your knowledge grow. But it's not going to grow just listening to me or somebody else, I'm going to always hit you with some things. My intent of doing this is just to number one, spread awareness. They don't like people to be aware of stuff. I want to spread awareness. I also want it to be known that people are not foolish for saying what they're saying. As a matter of fact, there's some seriously intelligent people who understand this information. As a matter of fact, I'm going to show you a state representative that's going to be using the right to travel next. As a matter of fact, let's go ahead and look at that right now. This is another video that's been on the internet for a long time. I'm kind of going into classic mode right now. And let's look at this this representative. He's gonna talk about some stuff. I think this will be very educational too. Let's check this out.
Is a military veteran, former cop, and 4-term state representative from Hooksett, New Hampshire. In the summer of 2016, he was arrested on a warrant for driving with an invalid license and released on $4,000 personal recognizance. He attended an arraignment in June and challenged the court's jurisdiction, among other things, and then was later arrested while campaigning on Election Day, November 9th. Police say he failed to appear at Concord District Court to answer to charges of driving while license suspended and prohibitions regarding an allegedly invalid license. This week, Dick was back in court for a case status hearing, where he let the judge have it in front of a full courtroom.
That's what my mother told me I would.
All right. Mr. Markle, this is scheduled for a case status hearing. All right. I know that you normally prefer to stay on the other side of the bench, but if you wish to come up, I understand that you still challenge the court's jurisdiction, but if it's easier and you think you can hear me better if you're at the table here, that's fine.
I'm going to pay the table number right now.
Okay, very good. I'll try and speak
There's a couple of things I'd like to point out. Of course, the seal that's above your head on the wall, that's a corporate seal.
Okay, hold on just a second.
And that's what we're talking about. I don't enter the corporate jurisdiction.
Okay, hold on just a minute. I just want to get the record straight. This is scheduled for a case status hearing. It was scheduled for a trial back in October. You failed to appear. A warrant was issued. You were picked up on the warrant, and the case was scheduled today for a case status hearing. Now go ahead. I know you had a couple challenges that you wish to put on the record, so go ahead.
You mentioned I picked up on a warrant. There's a few things that took place.
I want to bring everybody's attention to the fact that he didn't cross over the bar, and he brought to her attention, which she real quickly wanted to get around, that she have a corporate seal. The seal behind her is a corporate seal. That state of so-and-so that be behind them, that's a corporate seal. Now, this is a state representative. This is a state representative doing this, all right? So don't be trying to make it just seem like, oh, crazy-ass sovereign citizens. Well, obviously, that state right there was crazy enough to elect someone who understood this information, you know, so just something to ponder and think about.
After the election, and that is I received 2 documents which are, under the law, presentments from the corporation doing business as the court here. This is a private corporation. In fact, the Supreme Court of this state is a private corporation operating for profit and providing a judicial service to another corporation. And that corporation has as its seal above your head and what is here, top seal, on what I call the technical manual for legislators and judges. This is the supreme law of the land. And I'm going to refer to it right now because you mentioned the warrant that I was picked up on. Article 87 says former rich, that's a warrant. And I have no evidence that Article 87 was obeyed or complied with. After being arrested, I asked, I said, where's the warrant? They said, electronic warrant. I said, what's an electronic warrant? It has no signature of the court, has no signature of the, or seal of the court, has no signature for the, this is a violation of Article 87. I'm still submitted to the arrest because...
Are you referencing the New Hampshire Constitution when you say Article 87? Is that what you're...
Article 87 is specific. There's no amendment to Article 70 that I can find.
So that's the New Hampshire Constitution?
That's one of the issues that I say. Is a warrant wasn't a valid warrant.
All right, well...
So both of them. That's twice that you did it on me.
We have two issues to discuss. First is...
Okay, here's a very important point of contention that you have to be aware of. He's absolutely correct. He's in there quoting the Constitution, but I'm saying they're not operating under the Constitution. This is another thing that's not going to be revealed. First of all, they're operating under the plenary power doctrine. Okay, the legislature, this matter is legislative in nature. That means that they have plenary power over it because it's within their cognizance because the matter is commercial in nature. Okay, so they're not subject to the Constitution, none of the constitutional restraints. The constitutional restraints is to keep the public in the public and the private in the private. But right here, we're adjudicating a matter that is within their cognizance. And they're not, and so now this is not being said, but just looking at it, when he brought up the Constitution, okay, well, this is an Article I court. This is another reason that he's operating under presumption in my opinion. And this is why we got to come in and ask them what jurisdiction is. Yana, is this criminal or civil? It's criminal. Okay, let the record show that this is a criminal matter. Now I have another question. The Constitution for the United States of America only grants this court 2 criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. That's for the record, under which 2 of these jurisdictions is you going to try this criminal action? And you're asking that question. So stop. You're not operating under a presumption. You got to get them to answer the question. Okay, on the record. Okay, you can't answer the question for them. And sometimes people do that by assuming we're under the Constitution, assuming we're under common law, assuming, where's the injured party? You coming in saying all those things, you operating under a presumption. You're presuming that we're operating under the common law. And that's not what they're operating under. You need to ask them that question and establish that on the record first. I'm just saying.
Is whether the warrant was valid or not, all right, doesn't change right now for this proceeding the case status, which is basically just to schedule it for trial. Now, if you have an issue with the warrant, there's certainly other avenues available, but this court can't give you any relief for the warrant piece because that's an equity argument. So what we have left here is the charges against you. We need to reschedule them for trial. Now, the argument that you just started to make is a little different than the one you made the last time, that I deny your motion basically to
I didn't make a motion, ma'am.
Well,
I can't make a motion because I haven't given you
Let her
jurisdiction.
finish first, sir.
that's
Don't
all right.
interrupt her.
Mr. Markle and I have an understanding here. I understand you say that you are not going to file any motions, so I will refer to them as arguments, okay? But the reality is the court has...
Okay, now see, you see how he understood, hey, look, I'm not filing no motions because I'm not under your jurisdiction. But she came back with another chess move. Okay, they're not motions, they're not arguments. I'm not arguing here either. I'm not here to make an argument. When you have an argument, that's granting jurisdiction. That's something that's tested in a trial, a jury trial or a bench trial. They like to argue, attorneys like to argue. That is their domain. We don't live in the domain of arguing. We're not there to argue with these people. That's why you do an administrative process before you come to court. So you already have an agreement of the parties before you come in there. And because that's one of the things they like to do is say you're making an argument. I'm not making an argument over anything. I'm telling you, you don't got jurisdiction. I'm telling you, I'm not a 14th Amendment citizen. I'm telling you what my status is before the court. I'm not arguing with you about nothing. You know what I'm saying? This is what they say because they're always directing the record to reflect that they have jurisdiction, and if you don't address it, silence is acquiescence. This is this recontracting that people like to talk about. And that three rule I kept talking about, you have to say something 3 times. All that comes into play. So you got to understand you're in an adversarial proceeding. And, an area, it's like you got to be, alert to all of this kind of stuff. Especially when you're talking to a judge. Especially when you better respect a judge. They don't say nothing for no reason. You need to be acutely aware and paying attention to every word come out of their mouth when they're talking on the record.
Said we do have jurisdiction to hear the case of the driving without or driving after suspension. So what I'm going to do today is we're going to give you a new trial date. And I recognize that you have other arguments that you wish to make, and the ones that you were making today about the state of New Hampshire being a corporation is different than what you've argued before. So if you wish to submit some other documents about your argument of why, under that theory, the court doesn't have jurisdiction, you're welcome to do so. And do we have a trial date?
Yes, it's going to be on January 23rd at 1:30 p.m.
All right, so Peter, can you please give this to Ryan? You have that right? Or Jim, that's okay. And Jim.
Okay, she went in straight setting a trial date because what? She told him, well, we got jurisdiction over the driver's license. That's what we here talk about. You driving without a driver's license. Now, the secured party, we don't go to trial. You're supposed to have an agreement of the parties. See, a trial is for when there is no agreement. There's no stipulation between the parties. There's a material issue of fact. So now we got to go before a fact trier. A fact trier could be a bench trial or a jury trial. Fact finding. Go and get into fact finding. You can't go to law until you have the facts. Facts have to be agreed upon. What are the facts? We have to establish facts. Another reason you do an administrative process before you get to court. What are your facts? Facts are stipulations. Facts are things that have been agreed to. Agreement comes in express or implied. Silence is acquiescence. That's an agreement. These are, you're trying to reach agreements. And she's saying for the record, okay, your argument. So argument, we go on a trial. And what we're going to argue is about this driver's license. Were you driving? You had a license. Were you driving? Okay, and he's going to make the argument, no, I wasn't driving, I was traveling. All of this type of stuff. And it gets really interesting. It gets kind of long and drawn out because I think there's more than one video. But it's still interesting. Something is very educational. Let's look at it some more. Once again, I think this judge is pretty good. I think she's pretty good. You have to watch how they operate, how they get down.
If you would please give Mr. Marple his next court date. And then, Mr. Marple, I think you understand that anything that you wish to argue, you do need to put in writing, and then the state has an opportunity to respond.
Well, that's exactly why I want some questions answered here. And I think there's an obligation under Article 15, because I'm an accused, I'm not a defendant.
And
I'm only accused.
I changed that in your
And you
documents.
made a correction in the record.
Yes, I did.
Thank you. Now, this is what the document here that I received. And you'll see, this says criminal.
Okay, I had to make a point real quick because he said something nice. He said, I'm not the defendant, I'm the accused. The defendant is the all caps name on the caption of the pleading of the court paperwork, which of course we call a straw man, a legal fiction entity, an ens legis, a nom de gore, war name, whatever you want to call it, franchise, whatever. All right, transmitting utility. It goes by a variety of different names. All right, but we're talking about some sort of legal fiction entity that you're seeking to separate yourself from, that they've attempted to, connect you with this entity and operate under a presumption that you and this entity are one. But remember, public and private don't mix. So if you're a private citizen, you can't be in the public and the private at the same time. All right. So he's bringing up something. He's about to talk about something criminal, I heard him say, but I was just making you understand what was going on right there and just bringing out that point. He said, I'm not the defendant, I'm the accused.
On in a criminal case. If this is a criminal case, then you can have a jury trial. That's what this says, criminal. Now, I don't know, and that's why I said I'm completely confused of why I am here, and nobody is answering it.
Well, sir, as we've discussed, the state of New Hampshire has charged you with a Class B misdemeanor for driving, displaying a New Hampshire license that had been suspended, and for the violation of operating under suspension. Your trial date will be given to you, and either before that trial date, you don't need to have them sign anything, you just give it to me, please. Ms. Marble, on or before.
My man, he know his stuff though. Notice he didn't want to sign anything. If you sign anything, you grant jurisdiction. They go for if you're in jail, they'll try to set you up to get you to sign something. Trust me, you put your name on anything, you don't sign no documentation or nothing. Don't sign nothing. All of this stuff, he came and brought us something for him to sign. He said, nah. It's just things like this, little things like this. You go and watch the videos, you can see people who know what they're doing and people who don't. But there's a reason he doesn't want to sign anything. And that's one of the things. Remember, he's telling them you ain't got jurisdiction. So they hitting him all the time with something trying to get jurisdiction on them. They constantly throwing stuff at him, to try to get jurisdiction. There's always something, oh, you ain't got jurisdiction over you, huh? What about bam, bam, bam? You getting hit with stuff. And sometimes you don't recognize it. Sometimes you don't see it. You didn't see that's what it was. And they don't tell you that's what it was. And then you get mad, these motherfuckers just, they ain't pay attention to nothing I did. Well, it was the reason they didn't pay any attention to anything you did. They got jurisdiction. And it doesn't have to be through something you said or filed. It could be through your conduct. Remember, there's an urban legend about, a guy who's in court and he had some gum in his mouth and he had won. And then he turned around and was walking out. And then the judge told him, take that gum out of your mouth. And he took the gum out of his mouth and he told the bailiff to arrest him. That's an urban myth. But, I thought I would share it with y'all. A lot of people know that story, about your conduct, how your conduct can give away jurisdiction. That's what it was meant to teach you. You got to watch your conduct. Anytime you follow a direction of the court can only issue directions and orders over what it has jurisdiction over. So if you're following orders in the direction, it got jurisdiction over you. You know what I'm saying? Just things like that.
For that trial date, any other arguments that you want to make, you need to do them in writing. Then the state gets to respond, and then I will rule on them. But either way, the next court date, you're being given in hand, and that is your trial date. Thank you.
You have not, you're denying due process. You're denying due process, madam. That's what you did the last time.
She wanted to get the hell up on out of there. Well, you're going to court. Here's your court date, and you go put it in a motion, and he's going to respond. That's it. I'm through. I'm out. He ran up out of that courtroom. I wouldn't be surprised they have another judge. Sometimes you'll see another judge like, look, I don't want to fuck with that shit. They recuse themselves. Bring somebody else in. She ran up out of that courtroom, boy. Because he's going to hit her with some, they don't want to get questioned. They don't want to get, why is it they don't want people to know what's going on? What's the reason behind it? I know that's what people are asking. They're asking that question. Well, it has to deal with slavery, okay? And understanding and gaining an understanding of what true freedom is. Because the American people at this point, they don't understand, they've never really experienced true freedom. True freedom. They don't know what it is. They don't understand the principles on which this country was built, which is why they're bringing the country down right now. They're trying to bring the country down. To make the country strong, the people need to know the original, how the country was established, and understand that if they want to keep their freedom, they need to go back to the original spirit intent of the Constitution of how the country was formed, and our relationship with the government, the relationship the private people have with the government, with their public servants. There's a relationship dynamic that people have they're not made aware of. And what they're doing is they're pumping today is they're pumping dependency on government. And then there's some sort of secret cabal behind our government taking it over. So they want all of you dependent on government, and then it's going to be somebody pulling government strings behind the curtain. How you free yourself from that is don't have no dependency on government. That's how you free yourself from that. Stop depending on government. But that's going to require you to take responsibility and initiative, which are the qualities of sovereignty, which are the qualities. You can't be no fake sovereign. You can't be pump faking with this. You can't be pump faking with this right here. This is not nothing. This is not some sort of novelty in everything that you can take on and take off. It's not something that you just engage in just because you're trying to get out of something real quick. It is something you have to commit yourself to and live by on a daily basis. Anyway, let's continue.
You left without giving me due process.
You may be seated.
Okay, we have other people up here, so you're gonna have to shut that down.
As soon as he's done, I'll stop.
No, you're gonna shut it down because there's people up here who may be witnesses or victims. So you can shut it down now, or...
I'm going to record whatever goes on with this gentleman. So.
Once the judge comes back, you can. But we have victims, we have defendants, and everything else.
Are you threatening me?
No, I'm telling you that if you don't, you'll be arrested.
That sounds like a threat.
No, it's a fact. So what are you gonna do, sir?
I'll stop recording because you're threatening.
Whatever way you take it, please stop recording.
I already stopped. Okay?
We got a big problem here.
I'm a security guard. You need to file a motion with the judge.
I already done that. Let me show you.
May I check?
That's
Now, obviously somebody's still recording. I find that interesting. He must got a secret recorder on. I think this is free keen. I think that's what they did. They came in with the secret recordings and things like that. But it's really interesting. This is supposed to be a public venue. Yeah, have you ever wondered why in federal court they don't allow cameras, that they draw all the people in federal court? They have drawings of them and shit. You know, that's what I was wondering about that. You know, it's like, why you don't allow TV cameras in there if this is for the public? Because it's not for the public. It's under the jurisdiction of the United States. It's a corporate entity, and they make sure that you got a passport before you can come on the premises. Before you go into a federal courthouse, they want to make sure you got some sort of driver's license or some sort of proof that you're a U.S. citizen before you come into the building. Y'all better pay attention. This is all jurisdictional things. They want to ensure they got jurisdiction over you before you even come into the building. Understand that, you know what I'm saying? You know, y'all got to start thinking about everything that's going on, not just, oh, I went into the courtroom today or whatever. I'm going to do something, just see if I'm going to get out of this real quick. And then I'm going to go right back to living my life the same way I was.
been done.
What's the green light for?
I told you to stop recording. You can leave me alone now.
Do you have the volume going on? It's not recording anything?
You can leave me alone now.
I'm asking you a question.
I'm not answering your questions.
It's already been filed. It's been filed with the Secretary of State as well as both of you. I'm going to show it to you. No, I went to a restaurant. I'm giving you. That's not happening. Oh, it's not happening. You're going to divide your process.
That's what you want to call it. Let's talk out in the hall to these people.
No, we're talking right here.
Testing you with yours, recording. It's a fraud.
Does anyone have any paperwork for me that gave anybody?
He's going back to the judge. He's like,
This is what I want. The judge isn't in and there's victims and defendants here. You have to leave the courtroom. Sir, do I need to call state police?
Madam Magistrate, I'd like to have some clarification on what you told me relative to putting in writing what was necessary. That's already been done by a counter complaint, which I delivered to your clerk. I have a copy of it here. I also delivered a copy of an affidavit of default on you and the clerk for your failure to respond to the submission that I made in the form of an affidavit. Now, you know, if an affidavit is not... I'm not going to be interrupted by her. I'm speaking, and what I am true, I've been speaking speak.
Right now, hold on. You are actually interrupting another hearing right now. I understand you may want to interrupt me, but you're interrupting someone who is here for an arraignment. We had your status hearing. I understand you may have a question, but I'm asking only that you be respectful. If you don't want to be respectful of the court, you need to at least be respectful of everyone else in here who has court business as well. After I'm finished with everyone else, if you're filing what sounds like, I know you're not filing, if you're arguing a motion to reconsider, I will hear you after I've heard everyone else that's on the docket, because from the court's perspective, the case status hearing with you today, what needed to be accomplished today from the court's perspective was to give you a trial date. We have given you a trial date. If you're telling me that you've filed new documents since I ruled on the argument whether
that is correct. That is correct.
I have not seen those documents yet. I do not know.
I have them in front of me if you would like to look at them.
They may very
because you're acting without knowledge.
Well, and this isn't the time for us.
You just admitted you're acting without knowledge.
This is not the time to do the hearing on anything else you may wish to argue.
It isn't a question of argument, it's a question of presentation of fact.
Which
and you can arrest me for perjury if I violated my obligation in that.
See, she's a public servant, so she's going to stay within the bounds of procedure, and she's trying to stick to the procedures, and she's making statements so that kind of to reestablish on the record that they have jurisdiction of the matter by saying argument and motion for reconsideration, and he's saying, look, I'm not arguing anything. I have facts. Okay, I submitted to you an affidavit. An unrebutted affidavit stands in truth and commerce. So those are facts on the record. But see, a lot of times they just move ahead and just ignore all of that. See, a lot of stuff just gets ignored because they don't want to bring it onto the public record, and they just ignore what you're doing, and they just walk around calling you crazy. But a lot of things never see the light of day. And this man right here, he's going to make an argument. He's going to make a real good argument. He's a state representative. So he's not going to be easily ignored on what he's doing. Another thing that they do, they like to use intimidation. They always have some sort of, all of a sudden you come in and start talking, next thing you know, right next to you, some officers of the court just standing there. You could be polite as all get out, ain't said nothing to nobody. They still have people come stand next to you. You got to get past that intimidation stuff too, because they'll try to intimidate you. But threat, duress, and intimidation, the thing about threat, duress, and intimidation, if you give in to it, you agree to it. Don't nobody say it. Ain't nobody got no right not to make you afraid or anything. It's just like, fear is a choice. And fear is usually the result of ignorance. Some sort of ignorance on your part. But, fear is a choice. So just saying. I'm just throwing those out there and everything. So let's see what Dick Marple is saying.
Affidavit of truth.
Right, Mr. Marshall,
So
let me be clear about something. The court is willing to give you a full and fair hearing on any other arguments that you wish to make, as far as challenging the court's jurisdiction, challenging the warrant. However, that is not now. That is not today. That, as you know, the arguments that you wish, or the arguments you wish to make, will take some time to be heard. The state also has the opportunity to respond in writing. So what I am simply telling you today is your case today, what needed to be accomplished today has been accomplished. The court is happy to schedule another hearing just for your arguments, where I will give you my full attention. The state, you will be welcome to argue anything else you wish to argue. The state will have an opportunity to respond, and then I will make it a ruling. But that can't happen
You can't make
today.
it. What I'm trying to accomplish is to have you believe that you can't make a decision when you don't have jurisdiction. My challenge is jurisdiction. In personam jurisdiction and subject matter jurisdiction. Neither one are on the record. The reason being is I filed with you, and you have a copy of it, my oath purgatory. We went through that at the last encounter. And that oath purgatory removed me from your jurisdiction. That was done under 15 statutes at large, Chapter 249 of the United States, which you were compelled to comply with under Article 6, Paragraph 2 of the Constitution for the United States of America.
Right.
That's the Supreme Law.
I have two responses. One is I did make a ruling that you had jurisdiction. You're welcome to appeal that to the Supreme Court. If you
No, the Supreme Court had nothing to do with it.
But what I'm telling you is right now I'm going to ask that you refrain from making any further arguments today. The case status that was scheduled for today with your hearing has concluded. There is a courtroom full of people.
Now, if I heard her correctly, she said she ruled that the court does have jurisdiction, but I didn't hear any explanation as to why. You just said it. You know, we got jurisdiction, and they'll do that a lot. And that's what they do. They'll just say, well, we got jurisdiction, but not, well, wait a minute, hold on. How did you obtain jurisdiction? What are the minimum contacts that, you know, that can be identified on the record that gives you, he said, in personam jurisdiction and subject matter jurisdiction, you know, in this matter. You know, they're not doing that. They're not answering any questions. Okay, they just make a statement. And he's saying, well, look, how you setting court dates and all of that, and you ain't got jurisdiction over me. That's what we want. That's what I'm discussing. You just sitting there ignoring it. You sitting there setting plans. It's like having a crazy ass girlfriend. Like, look, we broke up. Well, you know, our anniversary coming up. Are you taking me out to eat? Look, girl, I told you we broke up. You know what I'm saying? Somebody just ignoring the shit that you're saying. You ain't not like I done broke up with you. And they just ignoring it. Like ain't nothing happened. Let's keep listening.
That are also legally and correctly here that their hearings need to go forward. I am happy to schedule another hearing where you will have as much time as you need to make any other arguments, but both sides need to be here. You need to be here, the prosecutor needs to be here for that. And we have to schedule that for another day. I'm going to ask you one more time and let you know that your hearing is over, and I'm going to ask you to please be respectful of the rest of the court proceedings. You're welcome to stay here if you wish, but you may not make any arguments right now. You're welcome to make them later.
You're using semantic subterfuge by calling it an argument. It is not an argument. You were delivered, or I should say your clerk was hand-delivered by me, an affidavit of default. So everything ceases because under Common versus Bowen, and I have the case right here, it is automatic estoppel. So what you're suggesting is as I waive my rights of estoppel, and I'm not waiving them. So there's nothing more to say.
Okay, from your standpoint, there's nothing.
You will read the affidavits.
I certainly will read anything that you filed. I have in the past, and I will continue to do so.
We've had 2 weeks to do it.
I didn't even know anything else had been filed. All right? Your case was given to me today. When we first called it, that was the first time I heard your additional arguments.
Well, the first affidavit was filed after you made set out your presentments, because the affidavit incorporated RSA 382A, subject matter, which is it comes under 3-501, which defines which you sent out. You sent out presentments asking me to be here. I offered to come.
I'm not going to argue with you.
That's not an argument. It's a fact.
I'm going to ask that you stop talking now. We need to proceed with the rest of the court hearings. I'm going to ask you to please be respectful and polite. I know you disagree with the court, and I am fine with that. However, you no longer have the floor. I need to continue with the rest of the hearings. You're welcome to stay, but you cannot continue to present anything now. If you do, it's going to be considered disruptive, and I don't want that to happen. I know you do not want that to happen. I know all you want is to be heard, and I will hear you further. And absolutely, and as I stated earlier, I'm happy to give you your due process, but we have to reschedule the hearing. This court was not prepared to hear all of your arguments today. The state was not prepared. The state has 10 days to respond to anything that you're saying. So this is going to be my last request, to please be respectful. I will give you as much due process as you want. I will give you another court date, and I will hear you out on anything and everything else that you wish to say. But it just can't be now. And I just don't want this to escalate. And I know you do not want it to be.
Article 15 and Article 12, but I'm just trying to go by the supreme law of the land, which is here.
Right.
And it's being ignored by this administrative tribunal.
Well, and I will give you an opportunity to further put that on the record at another hearing date. But again, this is my last, I really am just asking you to be respectful. Come back for that next court date, and I will give you as much time as you want. I will give you the opportunity to argue everything and anything that you want to make sure is on the record. And I think that's reasonable.
Then I understand justice delayed is justice denied. Is that correct?
I don't agree with that, sir.
That is?
I do not agree with that.
You don't agree with that?
No.
Well, then why have you delayed this matter? This is 3 times you've had me arrested twice on the defective warrants, not in accordance with Article 87.
Mr. Markle, this has got to stop today. Again, I'm happy to reschedule this for as much time as you want. Your alternative is to wait until I've dealt with everyone else here today, although the prosecutor is left, so that actually would work.
One party question, if I may.
Certainly.
Is this all being recorded? Is this
It's a verbal recording.
It is being recorded, as was the previous ones?
I assume so. They normally are.
Okay.
So, and you're welcome to ask if you wanted, if your reason for asking is because you wanted to have a copy of it, you can request that at the clerk's window as well.
All right, thank you very much.
Thank you, Mr. Markle. I appreciate your cooperation. This is the matter of State versus Sarah Williams.
You did great. Absolutely wonderful.
Yeah, that was
fantastic.
He did do good. What a lot of times there's this a citation of authority. It's called the belligerent claimant. Let me see if I can find it real quick. It's called the belligerent claimant. Let me show y'all this. Belligerent claimant. I hope it's still on the internet. Yeah, here it is right here. Is this it? Yep, this is it. If I can, all right, I used to keep this on somebody's website, but this is a citation of authority. What is it? United States versus Johnson. This is something I always remember. It's just something I always have in the back of my mind. And this is kind of what he was doing right there while he was going so hard at the judge, even to the point of almost risking contempt and getting cast into prison and or into jail, not prison, into jail. He said, the privilege against self-incrimination is neither accorded to the passive resistant nor the person who is ignorant of his rights, nor to one indifferent thereto. If you're indifferent to your rights, now they talk about the privilege of self-incrimination, which is under the, I thought it was, you have a right not to self-incriminate yourself. Of course, that's what the Fifth Amendment is about under the Constitution. So I don't understand why they labeled it a privilege, but so I don't know in what sense they're talking about. It's neither accorded to the passive, if you're passive, nor to the person who's ignorant of his rights, nor to the one indifferent thereto. It is a fighting clause. Its benefits can be retained only by sustained combat. It cannot be retained by an attorney or a solicitor. It is, and that's where you get, like in the corpus juris secundii under attorneys, where it says attorney's first duty is to the court and to the state and to the court and then to their client. You know, and then if you have an attorney, you're incompetent in some kind of way. This is why people don't want attorneys, which sometimes is good to have. If they give you a public defender, always accept it. Just make sure you give him a letter of instruction, but you don't never turn down a public defender. A public defender is a mouthpiece. A public defender allows you, he's like a gateway, allows you to communicate with the opposing side. You know, when you don't have that, you don't have that available to you. So I wouldn't suggest that you do it. A lot of people go in there and fire the public defender. You only fire a public defender if he's dishonored your request. So it is valid only when insisted upon by a belligerent claimant in person. The one who is persuaded by honeyed words or moral suasion to testify or produce documents rather than make a last-ditch stand simply loses the protection. Once he testifies to part, once he testifies to part, I don't think they wrote that right. He has waived his right and must on cross-examination, that's wrong, or otherwise he has to refuse. He got to be refused to testify and refuse to cross-examination. Otherwise, or to testify, he must refuse to answer or produce and test the matter in contempt proceedings by habeas corpus. That's right here what he said. He must refuse to answer or produce and test the matter in contempt proceedings or by habeas corpus. That was always interesting to me because it was in the spirit of Revelations 2. Was it 2:9, I think? KJV 2, was it Revelation 2:9? Oh, no, 2:10, yeah. Under 2:10 it says, fear none of the things which thou shalt suffer. Behold, the devil will cast some of you into prison, that ye may be tried, and you shall have a tribulation 10 days. Be thou faithful unto death, and I will give you the crown of life. And I used to read a lot of scripture and everything, and because when you look into scripture, you have to understand the people try to discount the Bible and things like that. It's just so foolish. The wisdom that is present in there, that's why it's important that you understand natural law principles. So when you read a religious text, you know what it's talking about. You know, your mind ain't in fantasy land, or you ain't no space cadet. Think about it, you know, angels flying out to the sky with wings on their back, little babies, and talking snakes and things like that. That's not the message that's being conveyed. That's not the message that's being conveyed. You know, it's some principles that are trying to be given to you, you know, that you can live your life. And you know, this is one of them right here. You know, it's like you got to be faithful. You know, some people will take you to the point where they'll throw you in jail for your beliefs or whatever you're saying. But you got to demonstrate that you're right. If you're right, that you're right. If you know that what you're saying is the truth, you have to stand on it. And sometimes, you know, that you will get tested by your freedom getting taken away for a period of time, like a contempt proceeding or something like that. He said he got arrested 2 times already. So I'm just letting y'all see the different kinds of people and the different levels of this. How some people are very committed to this, and they are not just sitting here, you know, just some weekend warrior or something with the information or something like that, where you need to be. Things that you need to take into consideration if you choose to go down that path, what you're going to have to encounter, what you're going to have to be prepared to do, what you're going to have to be prepared to endure. Sometimes somebody might take you to the point of despair. That's something you don't even want to damn experience. Despair is like a demon. That's torture. That's what demons do, torture you. Despair, where there's no hope, when you lose all hope. They try to kill that out of you. That's why you got to be spiritually grounded. You can't be doing this. You can't be claiming you're no sovereign and you talking. If you're a sovereign, what you're saying is you follow the wills of the Creator. You follow the will of the Creator. There's some law that you have to have. That's why you have to have some sort of covenant. What is it? What kind of contract are you in with the Most High? You have a contract with God, then you have a contract with your wife. These right here tell you, the first contract is tell you how you're going to conduct yourself in accordance with your fellow man. What creed that that you're operating under. So when people tell you that sovereigns don't follow any law, that's a goddamn lie. Only person that would say that is a person who is godless. And God don't have nothing to do with the state. The state don't have nothing to do. They totally, neutral when it comes to religion because there's supposed to be a separation of church and state. The church only got involved with the state when they started accepting Federal Reserve notes. That's a minimum contact. So now they need a 501c3. When the church don't need no permission to operate, but they need permission to take that money. Think about some things, man. They got a real good book. Let me give it to y'all right now. If you're in the church, everybody in the church should read this. It's on SPC University. And Caesar's Grip, here it is right here. This is a bad book right here. This is a bad book. This dude did all the research on the church. And no, the IRS and all of that, he got a little understanding of public and private as well. But this is some reviews and everything. It is impossible to have religious freedom in any nation where churches are licensed to government. In this book, Mr. Kershaw exposes the root cause problems of rampant and unhindered immorality, government tyranny and corruption, and the inability of the state-licensed church to offer any real hope for combating these devastating societal problems. For the first time in any book I'm aware of, the author offers a credible and absolutely indispensable solution for restoring what is the most important of all our rights: freedom of religion and its vital partner, freedom of speech. And Caesar's Grip is indispensable. Every concerned religious and freedom-loving American needs to read this tremendous book, and I agree. Now, another thing why it's called In Caesar's Grip is because of the story of Jesus Christ in the Bible when he asked them, do they have to pay taxes? And that's full of all kinds of signs. He said, let's go see if we can catch him in his talk. Remember, you got the Fifth Amendment. You have the right to be silent. Anything you say can and will be used against you. So when the Sadducees went to go and get him, they said, let's go catch him in his talk. Is it not law? Is it lawful to pay tribute to Caesar or taxes to Caesar? He said, show me the tribute money. Whose face is on the superscription? Caesar. He said, and render unto Caesar what is Caesar's, and unto the Lord what is the Lord's. That's the same thing that's going on with this Federal Reserve. Federal Reserve notes, and they have Federal Reserve districts. And then they have contracted with member banks that accept Federal Reserve notes, and grocery stores that accept Federal Reserve notes, and movie theaters that accept Federal Reserve notes. You're operating under a different jurisdiction. And you need a club membership card. It's called a Social Security number to operate in it. Because everything in that club, they need that number. Where's your club? Where's your Sam's Club card? Now you've been a member all your life, and now you want to come in and say you're not a member. Now you want to say you're not a member. And that's when the argument comes in. Yeah, I'm saying I'm not a member because you never told me I was a member. Hell, I know I had a membership. You didn't send me no damn application spelling out all the terms and conditions of the agreement. So how the fuck am I supposed to know? That's what people are saying. What people are saying, But that is where a lot of this stuff comes from. That's a real good book, In Caesar's Grip. Let me see. I'm gonna put the link for it. If y'all just want to download it right now, I'm gonna put the link in the chat. Y'all it'll be on SPC University too. But y'all can download. There's the link right there for you. Y'all can download it if you want. Where is it at? All right, so that was it. They got another one. I guess I'll do that tomorrow. I'll do some more tomorrow. I'm just doing videos, just telling y'all what to look for, understanding certain things so you know how to move, in court, because somebody's always asking me to do mock court Why do a mock court? Let's just look at the real courtroom proceedings and, and look and see what's going on. And I just give you my, opinion of what's going on. And, it's like, trust me, you got to just know certain principles and then a lot of times, see, what they try to lead people to believe on the other channels is that going there, he's an idiot. And that's not the case at all. A lot of times, them people don't know how to handle you. You come in there and you saying all this stuff. That's why you get all this court. They don't know how to handle you. A lot of times, you know what I'm saying? Are they trying to fatigue you into compliance, hoping you give up, get tired of coming into the courtroom? Like, man, look, let me just do a deal. They sit you in jail. Do you get tired of sitting in jail? Yeah, man, look, I'll just make a deal, man. Let me just sign this plea agreement and get the fuck up on out of here. They got a lot of little tactics, man. That's why you see the conviction rate is so high. They got tactics like a motherfucker. Don't sleep on these people now. Don't sleep on them. Respect their power. Respect the power that they got. I'm gonna tell you that. All right, the next case dismissed. I've been studying all this stuff for years. I haven't been confident enough to try it yet. That's fine, do all things in decency and order. Yeah, Mr. L, I cannot afford a super chat or much else as I'm currently paying on fines and I have 2 new court dates in 2 days. I could really use some advice on the current fines if I can get. I don't know what to tell you. Go and discharge him. I seen that damn icon before. I seen it somewhere. That Mike Hardy. I think I seen you before somewhere. But you're dealing with a fine. Then there ain't no money. We got SBC University. You got videos on there to talk about discharging debt all over the internet. Go watch a video. You ain't even told me the nature of what you're involved in or anything. And you don't have any money. Let me tell you something about not having any money. I don't feel sorry for you for not having no money. You're a man. As a man, I wouldn't even come into the public and make a statement like that. Because you know what? That just tells me that what you need to get right is your spirit. Because if you are experiencing lack of money, it's because you don't know who you are. And you have a disconnect with the creator of the boundless universe, especially if you keep on having problems and inviting problems into your life. So the first issue I would address, kind sir, is how you think. You seems like you have poverty thoughts and you're looking for some sort of handout. And the universe abhors a vacuum. So people who look for handouts or look for sympathy for their condition are just, you lacking spiritually. I give people money all the time. There's a book called The Law of Tenfold Return. You should go and check it out. Maybe you should do something, start studying videos on the law of attraction, like Kevin Trudeau's Your Wish is Your Command. Start conditioning your mind for wealth and success, and then you wouldn't have to worry about fines and things of that nature. It's not meant for a man. A man looking for sympathy because he lacks money is not very attractive. You supposed to be making some. I don't have a lot of sympathy for dudes. Hell, I went to jail 2 times and came out and made something of myself. And some of y'all ain't never been, not one time. You out here begging and everything. It's like, why would a person feel sympathy for that? If you like, when I got out of jail, let me tell you a story. I got out of jail. I didn't have nothing. I didn't have no clothes. I didn't have no car, and I didn't have any place to stay. All I had was the clothes on my back, and I think $200 in my pocket. That was it. I started my journey from that point, right there. I moved in with my aunt in Augusta, Georgia. She told me, she said, look, I don't want you getting in any trouble. You're going to go to school. If you're going to stay with me, you have to go to school full time. She's a doctor and a PhD, and she let me stay with her. And she was a dean of Augusta State University. So she let me come stay with her. So I don't got nothing. Ex-wife tripping on me, everything flipping on me, telling me I ain't shit, all this right here, just things ain't going too good. So I don't want to get back in trouble. And I had to find, I knew that I had to make enough money to have the lifestyle that I wanted to live. So I knew a job was not going to provide that. So if you want to make big money, you have to get involved in things that make big money. So real estate makes big money. Real estate makes big money, So I said, I wanted to get in commercial real estate, but I didn't have the means to do that, even though I attempted to do it. But it looked like it was going to be a little hard for me to get into it. So I decided I was going to go with vacant houses. I said, I'm going to flip these vacant houses because there was this principle: if you can't make money without money, you can't make money with money. And that is true as hell. It don't take money to make money. You can use money to make money, but it's not required. It's not required, especially in real estate. You don't need no money to make money in real estate. And I'll tell you how. All right, so didn't have a car. All right, so I'm in school full time. I'm taking classes in the morning and at night. My aunt wants me busy. She don't want me to have no idle time whatsoever. So I'm taking a full load. I got 4 classes. And by the way, I was on the dean's list every quarter, straight 4.0 GPA on the dean's list every quarter. So I'm just living at the school. Between I go to school 2 classes in the morning, 2 classes at night. So between the morning and night, I didn't go home. I'd put a backpack and I'd walk into the neighborhoods and start looking for vacant houses. So I'd write down the address to the vacant house. I would go to the tax assessor's office downtown and find out who the owner of the house was. And I'd also go to the bankruptcy court, and they had a computer on there, and I could pull up all the motions for release from automatic stay. Those are potentially motivated sellers because they about to get foreclosed on because the court is seeking to remove the stay of bankruptcy, and now they can seek to foreclose on the home. So I learned how to put together some letters in the college library. I type up the letters in between classes. I bought postage. I learned how to use mail merge and Word. So it just make one letter, and then I had all these addresses, put in all the addresses, send all the letters to all these people. I'd send it to them on a Thursday, and they start getting the calls on Saturday. I get the call from them. I looked at about walking, wrote down about 200 houses I looked at just walking. And so my next step was to contact them. So I started calling them too. I started looking them up in information, and I got about 25% of the people's names out of information. And so then I called them. The 7th person I called was a cat, and I asked him, I said, "You want to sell your home?" He said, "Yeah." I said, "Okay, I'm going to come by and look at it." But prior to that, I taught myself how to do comps, my own comps, and also to understand the cost of repairs, like how to put in a new HVAC, how much it costs, how much to do kitchen, bathroom, all of that. I almost became an expert in that. I could walk into a house and do a rough estimate of how much the house was worth and how much the repairs were, whether any hazmat issues with it or anything like that. Come in and do that. Then I learned how to negotiate. First principle of negotiation: he who names a price first loses. All right. So I'm going in there and I done negotiated a price on this. I done got the comps on it. I talked him down to about a $50,000 spread. All right. So now I don't have no money. So now I sign a contract with him. I give him $10 for consideration. I put a clause in there that's an out clause. The out clause is this contract is only good upon me obtaining acceptable financing. That's the clause I put in there. That's my out clause in case I couldn't make it happen. So next thing I do, I go put an ad in the newspaper: handyman special, deep discounts. That's all the ad was. Cost me $25. So I put $10 in to consummate the contract, to make it a binding contract, to get the consideration. And then I went and put an ad in the paper for $25. I done spent $35. Started getting calls. First dude called me, came out to the house. Now that I got it under contract for 30 days, I gave myself about 30 days to close. The richest man in Augusta came out. He negotiated the same price I did, so I knew I had gotten a low price. And then the second man that came, he gave me about a $5,000 spread. I was broke, just out of jail, and I took it. And that was my first deal. And I'd been out of jail like 30 days. So you can't tell me 30, 45 days, something like that. You can't tell me you can't do it. You can't do it. You know what I'm saying? It's like, ain't no excuses as a man. You should be able as a man to be dropped off in any remote place in the country. Nigga just kick you out the car and you figure out some kind of way to make something happen in that town, city, or wherever you're at. That's how you got to move as a man. But don't be coming to me looking for sympathy. I'm not going to give a man no sympathy. We got enough of that in our society right now. They emasculating all the men. And it's time for men to stand up and be men again and understand what your duties are as a protector and a provider and get up off that fucking couch playing video games and shit like that. Motherfucking video. How a man gonna sit around and play video games? Nigga, you supposed to be out conquering the world. And then find your woman that's gonna support that. Y'all done got this thought hip hop and all this shit right here. I'm all on the internet. I'm like, where are these people's parents? How is a young woman, this is what I got a question for people right here. How is a young woman that's under 25 don't understand a man don't want a woman that done had sex with about 50 to 100 different dudes? I look in these girls' faces, they look like nobody's ever told them that before. And then some of the young men, they ain't taught to not want a woman like that. They don't know either because ain't no man around telling them. They think it's normal. It's a matter of course. You just got this immorality that's just off the chain right now. And it's not a wonder that relationships ain't lasting. When you had a taste of 100 different things, how you going to be content with just one? And then the relationships ain't lasting. And you know why it's a concern? Because that's one of the pillars of the New World Order, for there to be no families. The state owns everything. That's communism. That's socialism. I'm seeing how they doing it. I'm watching them. And then the general population, they just completely oblivious to it. Ain't got no sense whatsoever. They think it's just happening. They don't understand that things are being orchestrated. You being controlled. It's incredible to me. That's what be getting under me. That's why I say things the way that I say. And I talk like this because I'm like, why y'all can't see this? Why are you so apathetic about it? Don't you see what's coming? You can't see what's coming? You think it's going to be all good. Okay. Those who hope to be both ignorant and free, open for something that never has been and never will be. That's Thomas Jefferson. If you expect them to be ignorant and free, you delusional. That shit don't coexist with each other. You're going to be free, you got to be knowledgeable. You shall know the truth, and the truth shall make you free. Hey, John 8:32, he said it. The truth is what's going to make you free. It didn't say set you free. It ain't never said set you free. You're made free. All right, so with that, I've been on a long time now, so I got almost 600 people on here. Wow, this might be a good time to come on at 11 o'clock at night. I'm like, well, shit, this look good. Look good right here, Freedom is a burden. Freedom is a burden. Yeah, it is. All right. That's it for tonight. Once again, SPC University, it's only $49 to join. I know somebody going to have a problem with that too. They going to have a problem with that too. It's like, damn, he charging $49. Fuck this nigga, you know what I'm saying? It's like, it's amazing, It's just amazing what people that, I think the reason that, like, in particular, our race, that it suffers is we got the wrong idea about money. I think it would be very helpful to people if they started listening to Reverend Ike. If you're a Christian, why don't you switch up and he's all over YouTube, and start watching some Reverend Ike videos. So you can kind of also see he's a mystic. He understands the true nature of God, and he understands abundance mindset, of having an abundant mindset, of how to eliminate yourself from problems. You got to immerse yourself in positivity. You got to eliminate all negativity outside your life. And I'm not saying that's easy to do, but that should be something that you're striving for, is not to have any negativity in your life, and never deal with people who don't reciprocate. If somebody's not reciprocating, they're using you. They're using you. And so if they're using you, they're stealing energy. So it's just like it's just like this. I used to have a real nice lawn, man. My lawn was just green. I love having a nice lawn. I like having the nicest yard in the neighborhood. I'm a yard guy. I like coming home. My shit just perfectly manicured and ain't a weed nowhere you can find in it. And how I made sure there wasn't no weeds in my yards, I used to hand pick weeds. I would get up in the morning early and get down on my hands and knees. I'm talking about even the smallest little weeds and everything that's real tiny. I do one section of the yard one day, another section the next day. It was like real therapeutic to me. And because of that, because those weeds are stealing water. They're stealing water. So when you get rid of all of them, I'm talking about every little one out of your yard, now it's like your yard can breathe. And you can just feel the energy of it. And that energy transforms into your house. That's why you don't see nobody in wealthy neighborhoods with bad yards. I go through Highland Park in Dallas, every fucking yard in the neighborhood is green, like they all manicured by the same motherfucking company. That's kind of like neighborhood I like to live in. Not nobody don't make my neighbor, he don't want to take care of the yard. He got weeds growing up and he's blowing seeds over into my yard. And I got to prune my yard periodically because he won't take care of his. He done made the biggest purchase of his life. He won't even take care of the yard. So those are things, but it's the same thing in your life. You got to get those weeds out. When you get those weeds out of your life, watch abundance start to flow. You're damming up your energy by dealing with people who don't reciprocate. You're damming your energy up. Listen, things flowed for me, money and all kind of shit flowed when I got rid of damn parasites. Parasites in your life. You got to click them off. You got to get them off of you. You got to get them off of you. They not, I go for a woman, man. I don't care. Your friend, you got home. I ain't just talking about women. I'm talking about friends. You got friends that'll leech off of me. I had male friends that'll leech off me. Females, they'll leech off of you. They ain't giving nothing in return, but every time they call you, they want something. You got to get rid of those people and deal with people who reciprocate. You need that energy. You need that reciprocation. You don't need energy vampires and people like that don't understand how energy is supposed to work. They don't understand that the universe is about balancement, that the universe is about exchange. Everything is about exchange. That's why if you expect something for nothing, that you are living in delusion, because the nature of the universe don't support that. So it's impossible for something to be free. You have to give something. Something has to be sacrificed in return. People who conduct magic know that. If you do magic, there's going to be a cause and effect on everything. There's this duality that exists, and that's the nature of the universe. So ain't nobody wrong when they're asking to be compensated for their energy. You need to respect that. And once you start because you're going to be expected to be compensated for something. You don't want to do anything for free. So, just understand that, it's like, have that attitude. I don't expect nobody to do nothing free for me. And I give money all the time because I understand also giving, but because I give because I know I'm going to receive. There's going to be some sort of corresponding thing that's going to come back to me. So I like to build up my bank account of gratitude, or zakat, charity, build up my storehouse of charity, so because I know it's going to come back around. There's maybe a time where I need something like that. But don't add, but hey, anyway, there's a lot of stuff on the internet about discharging debt. A lot of videos on this channel that I do for free. I got a ton of videos on here. I do it for free. You ain't got to come on a live and ask me to give you an answer that I've already given 1,000 times on other videos. I'm not going to keep repeating myself like that. Look for a video where I talk about it. I'm sure it's one on here. I got one called, I got a couple on here. Just look them up. Anyway, appreciate the $5, Twitch 307, Sarahi Cardenas. Boy, y'all got these names. $10. I appreciate that. Teardrop Hall, 20 bones. I appreciate that. Appreciate all the donations. Pole Ground, 5 bones. I appreciate that. Thank you for all the donation. Iris Rojas. Hey, Iris, what's happening? $2. I appreciate that, love. Appreciate that. Thank you. All right. Appreciate that. Hey, I'm out. I'll see y'all tomorrow. We're going to do another one. We'll sit back and chill out like, ain't just like we talking on the porch, talking about stuff, and just talk about these matters. It's a really interesting subject, this sovereignty and discharging debt and all that kind of stuff. But anyway, $49, SPC University. Get on over there and register. Register for Currency Circulator at no charge, no registration. A portion of your registration fee is going to go into Currency Circulator, and you get an opportunity to get up to $10, $15, maybe even $20,000, all right?